Right. Good morning, everybody. We'll postpone housekeeping matters till perhaps the lunchtime break. Mr. Marucci, you were indicating probably cross-examination up until about that point.
I think so, yeah. I mean, I discussed with my learned friend. I'll do my best to finish by then. I mean, I think we are beginning to think we may not get to evidence in chief of Mr. Collins today, but we'll have to see how we go. If we don't, it probably means we would need to sit on Thursday morning as well as Wednesday.
Right.
We'll have to see how we go.
No, okay, sorry, the hesitation is I've just arranged my travel and hire car for the site visit, but
yes,
well, I mean, it's quite understood.
Yeah, I mean, I think the plan would be, if possible, that we would still do the site visit on the Thursday, because I don't think we would need the whole day necessarily, and it's light a little bit later, obviously, but
yeah,
but we can see how we go.
Let's not worry about that.
Okay.
I mean, the point's understood completely. I'm not. Don't think I've had to chase anybody at all. And it's running very smoothly. And I appreciate there's a lot of ground to cover. So yeah, we'll break at lunchtime, either at the end of the cross-examination or possibly midway through. See how it goes. So you're getting there.
Hopefully not midway through. But
if we're midway through at lunchtime, yes, we need to really worry.
I think
we're past midway through. We're past midway.
No, I completely understand. There's a lot of material to get through. I fully understand. Okay, but in any event, when the cross-examination is finished, we'll pick up the housekeeping matters at that point. So
thank you. Morning, Mr. Johnson. Thank you.
Morning,
Mr. Johnson. When Mr. Collins and I were doing an inquiry, and our transport witness was cross-examined for 6 days, each morning he would sit in his chair and say, "Another day in paradise." So welcome back.
I'm getting off lightly.
Well, indeed, well, we'll see. Now, just to let you know where we're going, I mean, there are basically 3 broad topics that I need to cover over the remaining time. So obviously yesterday we spent a lot of time talking about paragraph 190A of the NPPF and need. So I need to complete 190 by looking with you first this morning at 190B, which is alternatives, and then C. Then I need to talk to you about benefits and harms of the scheme. And then finally, I need to talk to you about development plan compliance. So that's where we're going in terms of topics. So can I turn to 190B of the NPPF, which is the cost of and scope for developing outside the designated area or meeting the need for it in some other way. Yeah. Now, before we kind of descend into the detail of all of this, there is a key fault line between the council and the appellant, which I just want to identify with you to make sure that you and I understand where this dispute lies. Yes. And I think you can sum it up in this way, that the council's approach that you advocate for 190B is that we are looking for alternative sites for 111 units, whereas the appellant's view is that there have to be sufficient alternatives to meet the unmet needs for housing in this borough. Now, that is, isn't it, the key, or at least a key dispute between the appellant and the council, correct?
Yes, but however, that obviously what we're talking about here is if you're going to the alternative sites, that is just one way, obviously, of undertaking the assessment under paragraph 190, because it doesn't restrict us to that, does it?
No,
it's
but
it's just one way. But
well, no, it's not one way. I've said to you, I think, be quite clear about this. It's correct that there is no prescribed way in and of itself within paragraph 190B. But the point I've put to you is a bit different, isn't it, Mr. Johnson? The point I've put to you is that you are advocating an approach whereby the inspector should be setting out to look for a site or sites that could deliver 111 units, i.e. the number of units proposed in this scheme. And we are saying that is not the correct approach in this case. And the correct approach in this case is the inspector needs to look to see whether there are sufficient sites to meet the unmet needs for housing. I mean, those are the 2 competing positions, aren't they?
If we're restricting ourselves to discussion on alternative sites, mentioned, I believe it's the broader assessment that's required, but let's just take that. We are at difference on that matter. Yes, yeah. I mean, our approach is very much about there's 111 dwellings, and it's comparing like for like in terms of alternatives.
Well, Well, we'll come to whether it is your approach is actually about like for like, but just to be absolutely crystal clear, you accept that is the fault lines of the debate between us. You say we're looking for alternatives for 111 units. I say we're looking for sufficient alternative sites to meet the unmet needs of the borough. Yes, good.
Yes.
Now, what I want to do is just to begin with, we need to return briefly to both the Wealden case and the Turndon case and on this issue of alternatives. So let's do that first. Can we go, please, first of all, to the Wealden case, which is CD 10.1.
Yes, how
And
about,
if
thank
you
you.
go to electronic page 14,
Yes.
sorry, just give me a second. Yes, electronic page 14. You'll remember we looked at some of this yesterday, but you'll see at the top of the page there's a heading. Did the inspector misinterpret and misapply the policy in paragraph 116 of the NPPF? And we know, don't we, from paragraph 54 below, that paragraph 116 then is now paragraph 190. And if you then go to paragraph, 56, we looked at 55 yesterday. I don't want to go back to that, but paragraph 56. The Court of Appeal sets out an extract from the inspector's decision in Steel Cross that runs over the next couple of pages. And I don't want to go through all the detail of that, but I want to pick up just one thing, which I'll say to you just one aspect. You see paragraph 89 of the quotation. So you'll see the first paragraph that's quoted in paragraph 56 is paragraph 89 of the inspector's decision. And towards the bottom of that page, the last two lines, the inspector is recorded as saying, even if the search for alternative sites is taken wider than Crowborough, which is obviously where Steel Cross was, there is still a lack of housing land to meet the full OAN, and one alternative being considered when preparing the draft core strategy would itself be in the AONB. The existence of other sites which collectively still fall short of the full OAN does not amount to an alternative, and there are no plans through the duty to cooperate or otherwise for neighbouring districts to provide for the shortfall. So just as a matter of fact, can we agree at this point that the approach the inspector took at Steel Cross was the approach that I'm advocating our inspector should take at in this case, i.e. he said there are no alternatives unless you have sufficient alternatives to meet the unmet needs of the area. Factually, that was the approach taken, correct?
Yes.
Yes.
It is.
Now, then to see what happened in relation to that, if you drop down in the judgment, please, to paragraph 58. 58, the Court of Appeal records what happened in the High Court because the challenge to the inspector's approach succeeded in the High Court on this point and then was overturned in the Court of Appeal, so they upheld the inspector. And if you look at 58, second line, she, that's the judge below, accepted the argument that that he, which is the inspector, did not adequately assess alternative sites for the proposed development. And if you drop down 3 lines, there's a line that starts apart from the South East Crowborough site, and then it says this: he had made no findings about the availability and suitability of other sites in Crowborough put forward as alternatives by the council. He seems to have rejected other sites as alternatives, said the judge, not because they were unsuitable, but because taken cumulatively, they fell short of meeting the full objective need for housing in the area. The judge recognised possible alternative sites are only one of a number of factors to be considered in the policy, but she said the use of the word should indicates that it's a mandatory consideration. The inspector had not adequately investigated or assessed alternative sites either in Crowborough or the district as a whole, and so he had not properly applied the policy in the NPPF. This was, the judge said, a significant failure. So you see, don't you, Mr. Johnson, that the challenge that was made there was the inspector was wrong to take the approach that there would only be sufficient alternatives if you had enough alternatives to meet the unmet need of the district as a whole, and that the inspector had failed to individually assessed the merits of the individual sites put forward as alternatives because he'd taken that approach. You understand that's the way it was argued?
Yes, I do understand that.
Yeah,
Yes,
okay, good. Now, if you then go to paragraph 61, you'll see that Lord Justice Lindblom says, in my view, the treatment of the alternative sites does not display any error of law, and I disagree with the judge in relation to this matter. And then you'll see 62, one starts with the policy itself. The context here includes the familiar and important policies of the NPPF directed to the identification and meeting of housing needs. So I think we agreed this yesterday, but what the court is saying is that where you are dealing with a housing case and you're looking at need and alternatives to meeting need, one has to look at the NPPF and what it says about housing need, correct?
Yes.
Yes. And then it says the policy in paragraph 116 is a policy for development control, which is correct. It applies to development of all kinds, which is also correct, obviously. Where the proposal in question is a proposal for housing development, it must be read together with the policies for housing and supply in paragraphs 47 and 49 of the NPPF. The inspector was clearly well aware of those policies and their importance. So just pausing there, you'll remember yesterday I told you that paragraphs 47 and 49 of the old NPPF 2012, they're the paragraphs that deal with the requirement to boost the supply of housing and maintain a 5-year land supply, yes?
Yes.
So what's being said here by the Court of Appeal is a general comment, isn't it? That whenever you're dealing with housing development under what's now paragraph 190, you have to read what's now paragraph 190B with the housing need and supply policies in the NPPF, including the need to boost and the need for 5-year supply, yes?
Yes, you do, yes. And obviously in doing so, you're also applying footnote 7, so that's an obvious point to make. But...
Well, yeah, that is part of the NPPF, although it's not part, is it? Not part of paragraphs 47 and 49 as they now are. It's not part of the paragraphs dealing with boosting the supply or maintaining the 5-year land supply. Yes?
Yes.
Okay. Now, so that's that paragraph. And then 63, you'll see the judge gives some general guidance about the approach to this part of the NPPF. The policy requires the exercise of planning judgment, and I think you and I agree on that. The decision maker must consider whether there are exceptional circumstances justifying the grant of permission for the development in question, and whether the granting permission would be in the public interest. The 3 bullet points do not exclude other considerations relevant to those questions, and we've agreed that's the position, haven't we?
Yes,
yeah.
we have, yeah.
So it says the first requires the decision maker to consider the need for the development, including any national considerations, and then see what the judge says. For example, the considerations of national policy for housing need and supply. So again, we're being told, if you're looking at this, you've got to look at those policies, yes?
Yes, as national considerations.
Yeah, but in particular, those for the supply and need for housing, because that's what's being said here, yes?
It is, yes,
Yes,
but obviously with the planning judgment, you apply the same principles for the national considerations, don't you? So.
Okay. Then the second bullet point does not refer specifically to alternative sites. It refers to the cost and scope for development elsewhere outside the designated area and the possibility of meeting the development need in some other way. In many cases, this will involve consideration of alternative sites, but the policy does not prescribe for the decision maker how alternative sites are to be assessed in any particular case. It does not say this exercise must relate to the whole of the planning authority's area or any smaller or larger area than that. This will always depend on the circumstances of the case in hand. And then the third bullet point, which we'll come to later, requires you to consider any potential harm in the 3 respects referred to. And the 3 respects referred to are recreation, landscape, and other environment, correct?
Yes.
Now, just on this paragraph, I mean, obviously it's recording there that there is no prescribed way as to how you should approach alternatives in the policy itself. But what's being made also clear is that the scale of the scope of the alternatives analysis can vary. Sometimes you just look at the town concern, sometimes you look at the whole area, yes?
Yes.
And obviously we saw, didn't we, yesterday that at Sturt Farm, the council decided just to look at Hazelmere, didn't it? You remember we looked at that? They only
Yes,
looked
I do remember that, yes.
They only looked at alternatives in Hazelmere, not borough beyond Hazelmere, yes. But in this case, we've gone further, yes.
Yes, because paragraph 190 doesn't preclude preclude you from looking wider than just the settlement,
It-
so.
It doesn't, but what it does tell us is that we've already undertaken the agreed exercise between you and I of looking at alternatives, has already looked wider than did the council when they granted Sturt Farm, correct?
Yes, and
Yes.
rightly so, yes.
Now, if you then, we're nearly done with this. If you go to paragraph 66, the relevant need, and this is, I think, I will say to you now, Mr. Johnson, a key paragraph in terms of the dispute between you and me.
Mhm.
The relevant need in this case was not for a particular kind of development, such as a new supermarket, school, or sewage treatment works, for which only a very small number of potential sites might be available or suitable.
Mhm.
It was a general need for housing and affordable housing, but because most of the district was within the AONB, there were few alternative sites suitable for housing development that were not equally constrained. That is, in the language of the second bullet, paragraph 116, few such sites outside the designated area. This was a matter of fact found by the inspector. His conclusion that there was a lack of housing land to meet the full objectively assessed need was not limited to Crowborough. It was explicitly a conclusion on the basis of search for alternative sites wider than Crowborough. He was not satisfied that such other sites as were available for housing development in the district would be sufficient to meet the need, or that the shortfall would be made up by development elsewhere. This was a matter of judgment for him. He was also found that the other sites would collectively fall short of the full objectively assessed need, so they did not amount to an alternative. This too was a matter of planning judgment. He was also entitled to take into account, and there's a point about the withdrawal of their local plan. So effectively the plan had fallen behind schedule and been withdrawn. Now, I just wanted to ask you some questions about that, please. First of all, the need here. I just want to understand that with you. The need that we've been discussing is the need of the borough, isn't it? We've talked about the 5-year deficit of nearly 6,000 houses. We've talked about Mr. Neam's trajectories, which tell us at the end of the plan period we'll have somewhere between 2,000 and 8,000 deficit in housing. And we even looked, didn't we, Mr. Johnson, yesterday, even if we looked only at the LPP1 constrained target of 590, the council is still 2,000 homes short at the end of the 2032 period. So that's the need we've been discussing, isn't it, Mr. Johnson?
Yes. Yeah.
The need for housing in this area is not 111 units, is it?
I assume you're referring to the standard method.
No, I'm referring to, I'm referring to several things. I'm referring to, at the moment, you have a deficit on the 5-year supply based on the standard method of minus 5,777.
Yes.
Yeah. And against the position to 2032, the end of the plan period, depending on which trajectory of Mr. Neam's you use, the deficit is either somewhere between 2,000 and 8,000. Yes. Those are his trajectories.
I haven't run the arithmetic.
No. So take my word
No.
for it. That's correct.
Okay.
But even if we use the constrained LPP1 590 per annum figure, remember yesterday we agreed the council, according to Mr. Neam, and you haven't disputed this, end up with minus 2,000.
Applying the LPP1
Yeah.
figure.
So applying a constrained figure, you still get minus 2,000.
Yes, we spoke about that
But-
yesterday. Yeah.
Whatever the figure is for the need in this area, whether it's
Yeah.
minus 577, minus 2,000 or minus 8,000, it's not minus 111, is it? You're not 111 units short, are you?
No.
No. Now, we are looking for, under paragraph 190B, an alternative way of meeting the need. And I'm just suggest to you straight out, it's plainly wrong for you to be looking at alternatives for 111 units, because 111 units is not the need, never has been the need in this area, and is nowhere near the need, is it?
Well, I think, my reading of that paragraph from me is that it's requiring you to look at obviously the scope. And let's just go back to my point about this is quite a narrow interpretation of paragraph 190, because these are not checklists, each of these criteria that you have to stick to. You know, we have there's the scope within that paragraph look much wider, but let's just go down this route as we're talking about it now, that if you are looking to apply B, the paragraph refers to developing outside of the designated area or meeting the need for it in some other way. So the need being, if there's 111 dwellings proposed, it's for meeting that need for 111 dwellings in some other way.
But there's not
It
a
doesn't even
need.
have to be alternative sites. It can be in some other way, as you read that.
Well,
a very flexibly drafted paragraph.
well, no, not really, because it's telling you to look at whether there's an alternative way of meeting the need. And I simply put to you a very simple, basic point. In no conceivable way is the need in this borough 111 units. It's thousands of units, isn't it? The need.
It is in the borough, but you can't, I think, what I'd like to say is you can't expect a single site to meet the need of the whole borough, can you? It's the need. There's a requirement for 111 dwellings, or a proposal for 111 dwellings, and we're looking at alternatives for providing that elsewhere.
Yes, but what wording do you rely on in paragraph 190 to support the idea that we're looking for an alternative to the proposed development rather than an alternative to the need? Which words in paragraph 190 support that approach?
My view is that
Which words support that
B
approach? Well, okay,
that
which
approach.
words in B?
Scope for developing outside the designated area or meeting the need for it in some other way.
Yeah, but that says the need. It doesn't say for meeting, for providing the proposed development outside of the A and B. It says for meeting the need.
Well, I would disagree with that, because I think A deals with the need for development. So, okay, yes, we have a housing land supply shortfall,
Yeah.
as we did at last inquiry. There's no difference there between the need's greater now, but it was still substantially below 5 years then as it is now. So that's where it deals with need. B moves on from that point, and B refers to meeting the need for it in some other way. And when it refers to it, it's referring to the proposed development on the site, it.
The need for it. So if you take
Yes.
out we've got this, haven't we, on page 15, I think, of your proof, you set out paragraph 190. I think it's page 15 of the proof. So the cost of and scope for developing outside the designated area or meeting the need for it. But surely the need in B has to be the same as the need in A. Are you suggesting that the words the need have completely different meanings in A and B?
Yes, I do, yes.
Right, well that would be unlikely. So you're saying that the drafter thought that the need had a completely different meaning between two sub-paragraphs in the same paragraph, but didn't tell us that, is that right?
Because B is specifically dealing with developing outside the designated area. So it's dealing with the development, and it's referring to the need for it in some other way.
Right. Well, let me give you an example. Do you remember when we looked at paragraph 66 a moment ago? The judge said the relevant need in this case was not for a particular kind of development, such as, and then he gives various examples. Let me give you another example. Suppose nationally we need a new power station. And the power company comes along and they say, yes, we want to put this power station slap bang in the middle of the national landscape. And there's no question the country needs this power station. Absolutely essential national need. If you're looking for alternatives to meet that need, you just need an alternative site that could accommodate that development, don't you? Because you only need one power station, yeah? And
Yes.
you just need a piece of land
Yes.
for that to go on, yeah?
Yes.
But if the need is not for one power station, but the need is for several thousand houses, finding one alternative site where you could put 111 units or whatever it may be, that does not meet the need, does it? Because the need is for several thousand units.
It wouldn't in itself meet the need
No.
under criteria A, no.
No.
It'd be part of that.
No, okay. Now, just take it a bit further. I mean, the approach the inspector took in the Steel Cross case that we're looking at, and which the Court of Appeal upheld as being a valid approach, that's my approach, not your approach, isn't it? Because the inspector's approach was to look for whether there were enough alternative sites to meet all of the need in the borough. So that, you know, whether you say that's, you know, the required approach or the wrong approach, the inspector in that case took my approach, correct?
And paragraph 190 leaves that to decision
Yeah.
maker. That's yes, that's
Got that
entirely
point.
possible through 190. Yes.
Got that point, but this was a housing scheme,
Yes.
yeah, like us, in a constrained area, like us, yeah?
Yes.
All I want from you is, and I think you agree with me, that the inspector's approach in Steel Cross that was upheld by the Court of Appeal as being a valid approach, that's my approach, not your approach, correct?
Correct. Yes.
Yeah. Now, I'll come to Turndon in a minute. In Turndon, the inspector, who's upheld by the Secretary of State, takes the same approach, doesn't he? We can look at the detail, but it is the same approach.
It is the same approach,
Right.
but obviously the circumstances are very different for
Well,
that
they're not-
site compared to what we have here.
Well, no, they're not, are they? But let's just look at this a bit further. I am going to be saying to the inspector that in relation to housing schemes, we've got the Steel Cross one, which was for a broadly similar number of units, I think 135. Turndon, which I think you said was for a similar number, although it's a bit higher, 165, in a highly constrained national landscape. In both of those cases, the approach taken by the inspectors and upheld by, in one case, the Court of Appeal, and in the other, the Secretary of State, is the approach that I'm advocating to our inspector, correct?
I'd say yes, but I would just
Yeah.
caveat that obviously the decisions reached were based on planning circumstances in the round, weren't they? So we've
Yeah, yeah.
spoken about Turndon obviously being
Okay.
the Secretary of State's judgment was based on the fact that it was a
Right.
very, very well
But I've
progressed
taken,
allocation.
okay, but I've taken down your answer. Your answer is yes. So there are two cases where fellow inspectors have taken the approach that I'm advocating, not the approach you're taking. And those approaches have been endorsed by, in one case, the Court of Appeal, and in the second case, by the Secretary of State. And your answer is yes, but you say, obviously, one has to look at everything in the round, which is true. Of course, one has to look at everything in the round, yes. Now, I just want to understand that because I've put these two cases forward. They are housing cases, they are in national landscapes, they are in constrained areas, etc., etc. We have a number of appeal decisions in national landscapes, don't we, for housing schemes? We went through loads of them yesterday.
You did, yes.
Which appeal decision do you rely on where an inspector took the approach that you're advocating of only looking at an alternative for the precise number of units that were proposed in the scheme? Where do we see an inspector taking that approach?
In terms of not giving a yes or no answer to that, but in terms of responding as briefly and succinctly as I can, I haven't put forward any appeal schemes. And I noted at the last inquiry there were quite a few appeal schemes, some of which are the same, we discussed. The inspector reached his decision based on a number of schemes put forward at that point, but it's very easy, isn't it, to find an appeal scheme that takes you in a direction that you want to go in with your own case. And equally, it's quite easy to find appeal decisions that go in the opposite way.
Well, not
So
too easy because you haven't found any, have you?
Well, and the reason, it's not that I haven't found any, it's just that I don't think there's a huge amount of value in looking for appeal schemes to back up your argument. You can always find one that argues to go left, one that argues to go right. So, because each scheme is individual and assessed on its merits. So I don't think you can really take a whole load of examples and talk about them and say, well, they're exactly the same as what we have here, because they're all different and unique in their own way.
Well, I mean, I note that view. I mean, obviously, I disagree with it fundamentally, but I note the view that you expressed. But can I just come back to my question, please? I've put before this inquiry two inspectors' decisions, one of which was upheld by the Court of Appeal, one of which was upheld by the Secretary of State, where they take my approach on housing and alternatives. And the answer to my question is the council, neither at this inquiry nor the previous inquiry, has come up with a single example of an inspector having, in a housing case, applied the approach that you're advocating of only focusing on an alternative to the numbers proposed. Correct?
That's correct.
That is correct. Good. Now, just to finish off on Wealden, please, paragraph 68. of the Court of Appeal's decision. I think it's the last paragraph we need to look at. You remember that the judge complained that the failure of the inspector was that he hadn't gone through looking at all the individual sites to see whether they were suitable or deliverable, but had reached this much more broad brush approach, my approach, which is doesn't matter because all the alternatives have to add up to more than the need, or there isn't an alternative. And the judge says, I do not think the policy in paragraph 116 obliged the inspector to deal in his decision letter with every potential site for housing in the district one by one. And then the last sentence, the decisive consideration was clearly the remaining need for market and affordable housing, both in Crowborough and in the district as a whole. So what we can take from that, do you agree, is that the Court of Appeal said it's not actually necessary for an inspector to go through every single possible alternative. The inspector can take the view, as the inspector did there, that if you haven't got enough alternatives to meet the whole of the need for market and affordable housing, then there's no alternative. That's an approach that's open, at the very least, open to an inspector to take, yes?
It is open to the inspector, yeah.
Now, can we then just look at Turndon, please, on this point? And so that's NID 7.19. NID 7.19.
Thank you.
Okay, and could you start by going to electronic page 49?
Yes.
This is, I'm going to take you to a few paragraphs to begin with that are not the inspector's conclusions, but are setting out the various arguments of the parties, because we need to understand what was being argued in order to understand what conclusion the inspector came to on this particular issue that we're talking about. Now, this is in a section that's dealing with the case for Natural England. So remember, they objected on national landscape grounds. They attended the inquiry through council. They called, I think, 2 witnesses, as I recall. And if we look at paragraph 97, you'll see what they were arguing in relation to this particular issue. Natural England say that the other planning witnesses for the council and for the appellant agreed that the approach to alternatives must be taken seriously. NE adds that it's a case, quite simply, is that it has not been demonstrated that the 165 homes sought by this application cannot be provided outside the AONB, or that need for them cannot be met in another way. So the Natural England approach that they were advocating to the inspector and the Secretary of State in that case was effectively the approach that you advocate to our inspector, wasn't it? That you focus on whether there's an alternative to the specific number of houses that are being applied for, correct?
Yes.
Yes. Good. Now, if we then look at the council's case at this inquiry, so go to paragraph 390, please. This is paragraph 390, and this is under the council's case. So again, it's not the inspector's conclusions, but 390, electronic page 108. Yes. There's a heading 177B, that's obviously 190B, cost of and scope for developing outside. Now, yes. 390, with reference to Wealden, which is the case we just discussed, the council maintains that there does not have to be consideration of alternative sites. But if there is a consideration, it says the policy does not prescribe how the sites are to be assessed or how wide the search must be. Yes. It depends. Now that again has certainly some parallels, doesn't it, with what you're saying in this case, correct?
Yes, it's entirely open to the decision maker, yeah.
Okay. And then if we go to paragraph 575, please. So this is in the applicant's case. 575, electronic 155.
Yes, have that.
Starting with need, the applicant relies on there being a national, district and local need for housing, and in particular affordable housing. It adds that it is not contested by any professional witness that there is national need there being a housing crisis. The applicant says, Ms. Kent, who was the witness for Natural England, I think, accepted that there is an imperative to boost the supply of housing, and it's an important factor. The applicant adds need is so important that it, combined with no or limited localised landscape harm to the OMB, has been found to constitute exceptional circumstances. The applicant also states it's important to note the existence of other sites which collectively still fall short of the full OAN does not amount to an alternative for these purposes. So that argument of the applicant is the argument I'm making at this inquiry, isn't it? That last 3 lines. The applicant is making the same argument that I'm making here, correct?
Yes, it is. Yes.
Yes.
Yes, and there's a recognition, obviously, within that same paragraph, the limited/localised landscape harm.
Yes, which of course I say is also exactly what's present here, and you disagree. But that argument about, I mean, remember we're focusing on alternatives here.
Yeah.
That argument captured in the last sentence, the last 3 lines of 575, the argument that's being made by the applicant in Turndon is exactly the same argument I'm making here today, isn't it?
Yes, it does. Yeah.
Yes, it is. Good. Now, if you then go to 584, please.
Yeah. Yes.
584, if you go to Roman 4 of that, please.
Yes.
Again, this is the applicant's argument, not the conclusions. We'll come to those in a moment. Where the need and issue is area-wide, the extent of the consideration of alternatives is context dependent. In Wealden, there was both a district-wide need and a need in the town where the development was proposed. Now, just pausing there, I mean, just on need itself, we agreed, haven't we? There's a need both borough-wide and in this town, isn't there, for more housing, correct?
Yes, there is,
Yeah.
although that doesn't necessarily require the release of national landscape.
No,
just
okay.
because there's a need within Hazelmere.
No, although this council has already allocated sites in Hazelmere that are in the national landscape.
As allocations,
Yeah.
yes.
Then the district in this case was, as here, very largely AONB, and so most of it was equally constrained. So in Wealden and in Turndon, and in our case, we are in a highly constrained district in terms of other AONBs, because it's extensive AONB, yes?
Yes, established that, yes.
Yeah. And then there, the inspector said, even if the search for alternative sites is taken wider than Crowborough, there's a lack of housing land to meet the full OAN. The existence of other sites which collectively fall short of the full OAN does not amount to an alternative, and there are no plans through the duty to cooperate or otherwise for neighbouring districts to provide for the shortfall, and the Court of Appeal upheld the approach. So again, I mean, the argument being made by the applicant here in 584 Roman 4 is again exactly the argument I'm making to you today, isn't it?
Yeah.
Yeah. And then if you look at 587, I think it is.
Yes.
Actually, it's probably more about the need. I probably don't need to go to that. Let's just go forward to 648, paragraph 648 instead. I think we've talked about the need enough. 648, Roman 3.
Yes.
There are no proposed ways, Roman 3, 643, no proposed ways to meet this need through alternative sites. 70% of the borough is AONB. Sustainable options for meeting the agreed housing need, both locally and borough-wide, are limited. Adjacent boroughs are struggling to meet their own need. Much of that, if not all of it, is true of Waverley, isn't it, as well?
So I'm just reading that. There's 3 criteria. There's 5 criteria, sorry.
There's 5 points that are made here. And the third one is, I'm just looking at the key points are highly constrained, which we agree, limited sustainable options for meeting the need, and then adjacent boroughs are also struggling to meet their own need. And that's true of Waverley as well in its adjacent boroughs, correct?
Yes, that is correct.
That
yes.
is correct, yeah. Okay. Now, can we then look at the inspector's view, having seen all these arguments? Obviously, we've seen Naturally England take your position, and obviously the applicant takes my position. And if we go to the inspector's conclusions, if we could start with paragraph 802. I just want to touch on one point in 802. We dealt with this really yesterday, but you'll see in 802 the point that we discussed yesterday, that the inspector at the time he was reaching his conclusion only gives limited weight to the draft allocation, doesn't he, in Turndon?
The inspector did, yeah.
Yeah, because it had only just,
Yes,
only just come along.
timing, yeah.
And then if we go to 806, Cranbrook and its surroundings are within the AONB. There are areas within the parish that lie outside the AONB, but these are located well away from Cranbrook's LBD and have been rejected by council officers as being unsustainable. Natural England's not undertaken any assessment of the availability of alternative sites. CPRE can maintain, with reference to work undertaken for the neighbourhood plan, that there are alternative sites available to meet housing needs in the parish. And then 807, however, the evidence of Mr Hazelgrave, the council's planning witness, strongly indicates the sites referred to in the evidence of Councillor Warren and various others are not likely to be suitable, bearing in mind that they've all been rejected during the SHLA process or refused planning permission. Now, just on that point, we're going to look at the alternatives in a moment, but a number of those alternatives that are in the list have been considered and rejected in the previous LAR and or been refused planning permission, haven't they?
That does apply to some of them, yeah.
Yeah, it does apply to some of them. Okay, good. And 810 then of the inspector. There's therefore a very compelling case for the need for development of this type in Cranbrook. Given the absence of evidence to support the existence of realistic, genuine alternatives, it's also reasonable to conclude that this particular proposed development is needed in addition to the considerable benefits, etc. And then it refers to the various bodies recognising the benefits. So in relation to where we've got to in relation to all of these decisions, do you accept that the approach taken by the inspector at Turndon and the inspector at Steel Cross support my approach rather than yours?
I think so. The paragraph we were just dealing with particularly deals with the lack of realistic, genuine alternatives to paraphrase that. And I don't believe that is the situation we have with the appeal site.
Right, but if you go back to 802 of the inspector's report here.
Yes.
So he refers to the local plan emerging, and he says, fourth line down, the work shows conceptually at least there are very likely to be other sites in the borough where housing of the scale and type here proposed might be delivered. So there are alternatives. However, as the proposed housing allocation sites in the ELP are all needed to meet the OAN as it currently stands, they cannot be considered to be alternatives to the application site. Now, just pausing there, that is, you don't agree that this should be the approach taken here, but that is an endorsement of the approach that I'm urging on the inspector in this case, isn't it? Because there wasn't enough to meet the full need, there are no alternatives, full stop.
That is your approach,
Yeah.
but that is not the approach I believe paragraph 190 advocates.
Well, that's not what I asked you. What I asked you was the approach I'm advocating was absolutely the approach taken by this inspector, wasn't it? And 802 is clear as day on that, isn't it?
But obviously, but not by the Secretary of State's decision, but by that inspector. Yes.
Well, so just pause. You agree the inspector took exactly my approach, correct?
And it's within the gift of the decision maker to do that, yes.
Right, so yes is the answer.
There's sufficient flexibility in 190 to take that approach.
Right.
Yeah.
So both at Steel Cross and in Turndon, that was my approach, was the approach that was taken. Now, just to pick you up on that, are you suggesting the Secretary of State didn't take that approach? Is that what you're saying? I mean, are you saying? I mean, you're not saying the Secretary of State explicitly disagreed with that approach, are you? Let's just take that first of all. Did the Secretary of State say, I reject that approach?
No, I don't think they commented on that specific approach.
Okay.
Either way,
Okay, well, I mean, let's look at very briefly paragraph 42 of the Secretary of State's decision letter.
you have a page number for that?
Yes, it's electronic page 11.
11, thank you.
Remember that paragraph we were just looking at was paragraph 802. So I ask you just to note that. In reaching her conclusions on housing need and delivery, the Secretary of State's taken account of the effect of the framework, which means that the Council can now demonstrate a framework compliant housing land supply and progress on the ELP since the previous decision. So they actually didn't have a deficit in their housing land supply by the time of the Secretary of State's decision. Now, the reason for that was that they didn't have to show a 5-year supply. They only had to show, I think, a 4-year supply by this point because of the 2023 MPPF. So there wasn't actually a deficit in the 5 or 4-year housing supply, right?
No, they did. Yeah, they had the benefit. Certainly had the benefit of that. Yes,
They had the benefit
as
of
well
that.
as
Yeah,
the
so they-
allocation as well. So,
Okay.
yeah.
And then it says, as a result, she considers that some elements of the inspector's conclusions at 801 to 810 in respect of housing need and delivery are now out of date. However, it's undoubtedly still the case that the ability to respond to the need for housing is heavily constrained. And on the basis of the evidence before her, in particular, significant weight gives to the draft allocation. She agrees with the inspector that it's reasonable to conclude that there's a compelling case for the need for development of this type in Cranbrook. She further agrees that there are considerable benefits associated with delivering market and affordable housing. And in reaching this conclusion, she takes account of paragraph 60, which sets out the objective of boosting the supply of housing. So, I mean, there is no explicit rejection in any way, is there, by the Secretary of State of the approach that one sees in paragraph 802, that if you're looking at alternatives, one doesn't find an alternative unless there are sufficient to meet all the need. Yes, there's no rejection of that, is there?
There's no rejection. No.
But of course, the position actually by the time the Secretary of State looks at it was that they didn't actually have a shortfall in their 4-year housing land supply. But despite that, the Secretary of State still thought there was an acute need for housing, yes?
Yes, the national need, yes.
Okay. Now, just trying to draw that together, you make some points in your proof, please, at 9.12 about the principles that you say should be applied in looking at alternatives. Sorry, not 9.10, sorry, 9.10. So you've got a heading in B. Your heading is, I note, whether there is scope for developing 111 dwellings outside the national landscape. So obviously, disagree on your heading, because obviously we say that's the wrong approach, but that's your approach. And then if you go over to the page, to page 22, you set out under 3 Roman numerals what you effectively say are the principles that you say should be applied. And you say, in consideration of exceptional circumstances, paragraph 190 requires assessments to include scope for developing outside of the protected landscape. It does not limit the decision maker just to criteria A to C. Criteria B reinforces this through allowing an assessment of meeting the housing needs in some other ways. And then you say, for these reasons, I've undertaken to include in my assessment a number of sites that are wholly within the national landscape, yes?
Some of them are, yes.
Yeah. Now, I mean, just to sort of break that down, what you're saying there, as I understand it, is that if you actually look at what's said in paragraph 190B, it's the cost of and scope for developing outside the designated area. So that's one aspect of it. And then the other is meet the need for it in some other way. Yes?
Yes.
So just to be clear on that, if you're looking to find whether there's scope to develop outside the designated area, that first part is looking at sites outside the national landscape. Yes?
Yes.
But the second part, I think this is what you're saying, the second part, and you're right about this, means you could look at alternatives which meant alternatives within the national landscape,
Yes.
because they'd be alternative ways of meeting the need but
some other way.
some other way.
Yes.
And that's why you've looked at a number of sites as alternatives that are themselves in the national landscape, like our site, yes?
Yes.
Yeah. When we come to them, I mean, I think it's right, isn't it, that the last 4 of those that you list there, so 15, 16, 17 and 18, I mean, where you get to on those is you actually think that they are effectively worse in terms of impact than us.
Yes, I do. Yes.
So you don't really consider those to be alternatives in the end, do you?
They were part of my assessment, and I think it's right to assess them. But I think if you were to rank the sites,
Yeah.
I would say they are
Okay.
poorer alternatives in the appeals.
Yeah, and that's just in landscape terms, is it, or just is it a more general assessment?
It's a more general
Okay,
assessment.
that's
yeah.
fine. That's good. And then you say the status of the draft plan and the likely review time frame whereby some or all of the sites in table 2 may come forward for allocation. Now, I think we've talked about the timetable for the plan ad nauseum, so I don't particularly wish to go back to that topic. The truth of the matter is, though, that the council has had a call for sites, as we discussed yesterday, open for, well, it was open, as I just think we discussed, wasn't it, for a period of time. But it's 18 months ago that it opened, and it closed, I think, about 15 months ago. I mean, by the way, just on that, Mr. Johnson, last night we had a go at seeing whether you could submit a site under the call for sites, and you can't because it's closed. So the actual call for sites is closed. You can't submit a site through that system. So if you're going to promote a site, you'd have to do what? Just write to the council, would you?
You would, as I would for most of my house builder clients, would submit the site via email with various background documents, supporting material. You'd send it in to the planning policy team via email, yes.
All right. But that
they would accept, I'm pretty sure they'd accept that.
Well,
most authorities would.
Yeah,
Particularly where there's a land supply shortfall, such as we have here.
Don't call for sites normally have a sort of base date that's set so they can actually assess them? I mean, I don't know how, don't they normally have a base date that you kind of take for the purpose?
In my experience, it's a formal consultation period at the start and a finish to that.
Okay,
but in my experience also, that it's pretty much judged as a live process.
All right.
By all the planning policy departments I've worked with over the last 25 years, it's an open process. They're always willing to receive sites.
Okay. Now, I think what you then say, is if you look at your Roman 2,
yes.
You say paragraph 90 does not require the assessment to identify sufficient sites to meet the full 5-year housing land supply shortfall and the LPP1 housing requirement within the plan period, only to accommodate the proposed 111 dwellings proposed.
Yes.
Now, again, that's encompassing, isn't it? Encapsulating, maybe the right word, the debate between you and I about what the proper approach is. Yes.
Yes.
But when you say paragraph 190 does not require the assessment to identify sufficient sites to meet the full 5-year housing land supply shortfall,
no.
I mean, you accept at the very least that that is an approach that is open to take, that you look for sites to meet the full need.
Yes, I accept that is an approach. Yeah.
And if we are going to only look for sites that meet the need for 111 units, we're also agreed, aren't we, that that in no way meets the need of the borough for more housing, does it?
No, and you'd never expect it to either, would you, on a single site?
No, but it's not really about whether it's on a single site. I mean, the important point is that the need for housing in this borough is far greater than 111.
Yes.
Yeah, okay. Now, I just wanted to sort of pull out a few further things on this, really. Now, I don't agree, obviously, with your approach that we're only looking for alternatives for 111 dwellings, but can I just explore with you how that would work if that was the approach that you were going to take? And what I want to understand from you, please, is you focus on 111 dwellings because that is what we're proposing within our scheme. That is the proposed development.
Yes.
Right. But the proposed development is for 111 units above policy compliant level of affordable housing and a SANG that, whether it's 9 or 12 hectares, is large enough to function as a SANG, not just for our site, but for other houses. Plus, we're providing parkland open space management of an area of national landscape of about 20 hectares. You haven't looked, have you, for alternatives that could provide all of that? You've literally just narrowly looked for alternatives that could provide 111 dwellings.
Because they're the benefits of the scheme.
No. Well, they're one of the benefits of the scheme.
Or some of the benefits.
Some of the benefits, but there are benefits from the whole scheme. So what I don't understand is, if we're not going to look at the need, and we're going to look instead at whether there is an alternative to the proposed development, you're only looking for alternatives on your approach for part of the proposed development, aren't you?
Because the issue that goes to the heart of the matter is the proposal for 111 dwellings.
Well, not
It's the approach I've taken is yes, you look at alternative sites as one of the approaches under Para 190, but you undertake that on a like-for-like basis. But the focus is the 111 dwellings.
right, but you haven't undertaken any assessment, for example, even if we focus on the housing. If we're going to look at really small sites to make up that 111, they may well not yield any affordable housing. Correct?
Well, if they were below the affordable housing threshold, yes.
Yeah.
And there's other things they may not deliver as well, like the SANG.
Well, they certainly won't deliver that.
But they don't need to, do they, if they're below the thresholds in the local plan?
Yes,
they don't all need to deliver SANG.
You say you don't need to deliver SANG, but remember, and I know you weren't clear about this yesterday, and I need to come back to it, but our SANG is not just about mitigating the impact of our scheme. Our SANG is a strategic SANG, which could also provide mitigation for a wide range of other housing, including in Hazelmere itself. So that's not just about mitigation, it's about a benefit of our scheme, and that benefit of a strategic SANG is not replicated in any of the alternatives, is it?
No, there's no strategic SANG.
No. Okay.
Yeah,
And then I know, we don't necessarily agree on the need for this, but obviously there's a dispute between you and I, which we discussed yesterday, about the need for the Scout facility. But if there is a need for the Scout facility, you've not looked at whether any of these alternative sites could meet the need for a Scout facility, correct?
No.
No. Okay.
No.
Now, the approach that you've taken in your paragraph Roman 2, that approach that you've taken at Roman paragraph 2, that is a different approach, isn't it? A different approach, as we've seen, to the one that was taken by the two inspectors that we've been considering, Steelcross and Turndon, correct?
That is correct, but obviously I'll make reference to the Secretary of State's decision, Turndon obviously, but the Secretary of State, well, I don't know where you're going with that, because let's just explore that for a moment. Did the Secretary of State have to consider whether there were alternatives under 190B? Well, the Secretary of State had to apply 190B, yes.
Yeah, okay.
And
We know from what the inspector said that there were plenty of sites in and around that could be alternatives. So if the Secretary of State was going to dismiss those on your basis, she would have to have gone through and looked at those sites. But she doesn't do that, does she? Because she just says there's need. So isn't, in the end, the Secretary of State's approach just my approach?
I think the Secretary of State was heavily guided by the fact we had in that case, there was an allocation that was virtually given the same weight as an adopted allocation.
Well, but that's just not relevant to this point, is it? Because
I think that was what was guiding, due respect, that was guiding the Secretary of State's decision.
yes, but
That was very much part of that, because that's
did the
the fundamental difference between that side and this side, isn't it?
Did the Secretary of State have to consider alternatives?
Yes, they did. Yes.
Does the fact that our site, the site in Turndon, the Turndon site, was allocated, does that mean the Secretary of State didn't have to consider alternatives?
Well, no, but
No.
if I can just caveat that, the Secretary of State had to look for scope for developing outside of the designated area or meeting the, not necessarily, it doesn't actually refer to identifying alternatives, does it, that paragraph? Just refers to scope for developing outside of the designated area.
Yes, but there's only
So-
one way the Secretary of State's decision could have been justified in not running through all the alternatives, and that's because the Secretary of State took the same approach as the inspector, that was, Well, it doesn't matter that there are lots of other alternatives for 165 units. The fact is, there's an overall need in the borough which, isn't met, yes? Otherwise, the Secretary of State would have to have gone through that exercise, and they didn't, did she?
No.
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 Okay, good. Now,
Sorry, just before we leave Turndon again, I just want to be absolutely clear because you've referred back to the Secretary of State's position in Turndon a couple of times.
Yes.
So we know what the inspector's position was. And effectively, I mean, tell me if this isn't what you're saying, but the way I read it, the Secretary of State was silent on that matter. There was all sorts of analysis that the Secretary of State undertook, but was it he or she at the time?
She.
Yes,
sir.
But the Secretary of State did not go back on what the inspector had concluded.
No, I believe she was silent on that.
She was silent.
Yes.
Okay, no, that's
Right,
fine.
yes.
I just wanted to be 100% clear on what you're saying on that. Okay,
Yeah.
thank you.
but so can I just I'm going to push it just one bit further with this witness in relation to that point. It's a useful sort of clarification. I mean, the Secretary of State was silent in that didn't explicitly endorse. Obviously, there was a debate before the inspector. Do you look for an alternative for 165, or do you look for alternatives that would meet the whole need of the borough? And we know the inspector came down on my side on that, rather than on your side. The Secretary of State's silent on it, but if the Secretary of State was taking the approach that you're advocating, that we're only looking for alternatives for 165 units, the Secretary of State would have to, wouldn't she, have actually looked at the alternatives and considered whether they would satisfy the 165. You'd have to do that if you were taking your approach, wouldn't you? You can't just brush the alternatives aside, can you?
I think the Secretary of State was reading 190 as I read it, looking at scope. We've dealt with scope for developing outside the designated area, but of course there's the tail to that, or meeting the need in some other way. So it could have been, she could have taken a much broader view than just looking at alternatives. She was potentially looking at meeting the need in some other way. But I'll go back to my point. I think the fundamental driver for that decision was that you had a application appeal on a site that was on a draft allocation that was pretty much adopted. And I think she gave it significant weight, not full weight, because it wasn't quite adopted. So I think that was the real driver behind that decision of the Secretary of State.
But it's irrelevant.
It's completely different to what we've got here.
It's irrelevant to the consideration of alternatives. It doesn't matter whether your site is not allocated, a draft allocation, or allocated. Paragraph 190B applies to all of those situations and must be considered. Yes?
Yes, in full. Yes.
Yes.
As in yes.
So doesn't matter whether a site's unallocated, draft allocation, or allocated. You have to comply with the requirement of 190B to consider the scope for and cost of developing outside of the national landscape. Yes?
Yes, you do
Now,
comply with that as well, yeah.
Yeah. Now, if the Secretary of State was doing anything other than taking the same approach as the inspector on this, i.e., that there are no alternatives because you have not got enough sites to meet the whole need of the borough, my approach, the Secretary of State would have to have examined individually the alternative sites that were in debate, because there were a number of sites that were in debate. But the Secretary of State doesn't do that, does she?
She's silent on that.
No, she's silent on it, but she can only be silent on it because she's endorsing the inspector's approach, that you don't have to look at all the individual alternatives because there's just an overriding need. Yes?
Well, yes, but I because the Secretary of State was silent on the matter, I don't know, we don't know, if she was giving consideration to how the need could be met in some other way other than just on the alternatives. We don't know, do we?
Well, except what we do know is, I mean, the overall conclusion of the inspector in this section is paragraph 810, which I read to you. So there's a whole sort of build up to it, and it concludes at paragraph 810. The inspector's position at 810 is specifically endorsed by the Secretary of State in paragraph 42, isn't it?
So you'll have to refer
look at paragraph
back to
42 of the decision. Remember, we looked at paragraph 42 a moment ago. I think you just referred.
Yes.
Yeah, you referred me to it, didn't you? And you'll see about 5 lines from the item. She further agrees considerable benefits associated with delivering the affordable housing That's paragraph 8.10. You'll also see above that, she agrees with the inspector, paragraph 8.10, it's reasonable to conclude that there is a compelling case for the need for development of this type and in Cranbrook. So she specifically endorses, doesn't she, paragraph 810, is that correct?
To be fair, because we've been over this for about an hour, the earlier part was she accepts some of it, and the lines above was out of date as well in that information I want to say. I mean, I don't want to interrupt my learned friend, but there's only so long one could go on about a single decision.
Well, I'll put it to you again, she endorsed the inspector's overall conclusion at paragraph 810. Correct?
Sorry, Mr. Marucci, you're going to have to take me back to that. If we're going to deal with it
Back to
properly
what?
before I give my opinion.
Back to what?
So back to paragraph 42, the line
Yeah,
you're
okay.
taking here. Don't mind.
Okay, yeah, are you on paragraph 42?
I am, yes.
Okay, so you'll see about halfway down,
Yes.
significant weight which she attaches to policy, etc. She agrees with the inspector at 810 that it's reasonable to conclude there's a compelling case for the need for development of this type and in Cranbrook. That's a specific endorsement of paragraph 810, isn't it?
Yes.
Yeah. Okay.
Yes.
All right. Look, let's move on to let's move on from this. Now, I just wanted to check with you. We were going through your, weren't we, your paragraph 9.10. Now, what I just wanted to understand with you was in your proof at 9.11, you say, I've undertaken a narrow assessment of whether there are potential alternative sites that could be developed for 111 dwellings, as standalone sites or in combination, and that would outperform the site. And then if you go to 9.29 of your proof, after you've looked at the alternatives, you say again, I consider on the narrow consideration of alternatives put forward that I have demonstrated there are sequentially preferable sites capable of accommodating a significantly larger quantum of development than the appeal proposal, notwithstanding opportunities for further sites to come forward through other sources, such as the call for sites and the local plan review.
Yes.
Now, you often refer to the exercise of looking at these alternatives, if we're going to do that, sites 1 to 18, as a narrow approach. But we've agreed that that's what we're going to do for the purposes of this inquiry, is it not?
It's one approach, but we're certainly not restricted to that, are we? Because as para 190 reads, consideration of such application should include an assessment of. It's the key word there being and include. Not be restricted to.
But the whole purpose of this being subject to the CMC direction was that both sides would put forward any site that they considered to be an alternative. And the only sites that both parties have been able to come up with are the 18 in that table, correct?
Yeah, I think for the purposes of brevity, if you're going to go down that narrow assessment as part of the overall assessment, let's just agree on the sites. And I think that was a worthwhile exercise.
But you say that narrow assessment, but we can only look at sites that have actually put forward as alternatives, can't we? Can't look at others.
Well, yes, because as I said earlier, you've got this call for sites, you've got this emerging local plan. We all know there will be many, many sites being submitted, but we don't know what they are yet.
That's just mere speculation.
Well, we know with a fair degree of confidence there are going to be a number of sites coming through. As there is in every authority in the southeast.
You might know that, I don't know, but we asked for the LAR or draft of the LAR and we've been told it doesn't exist. So the truth of the matter is we have literally no idea what has come in response to the call of site. There's nothing in the public domain to help us on that, is there?
All I have to go on is my many years of experience as a charter planner, that there will be many, many sites, and I've worked on both sides of the fence, including a planning policy department. There'll be many, many sites being submitted as part of that emerging local plan.
You can call it a narrow approach if you like. I don't really know where that takes us, but the parties have agreed in the statement of common ground that the only alternatives that are open for discussion, that anyone has any idea about or knows about, or in the public domain, are those 18, correct?
I think if you're going to go down the narrow approach, yes, we could be here all day. We could be here all week talking about sites if we just leave it open to both sides to pick and choose sites. It's a worthwhile exercise to draw the parameters to those 18 sites, yes.
Let me just put it a different way. Let's suppose the inspector decides to actually run through all of these 18 sites in the decision rather than taking my approach that you don't need to do that because it doesn't meet the OAN. If the inspector concludes all of these 18 sites, you know, that there is no certainty that they would come forward, you're not suggesting the inspector could still go on and say that there were alternatives elsewhere because he's got no information, has he, about any other alternative?
Well, no, I would say that, yes, because under para 190, you could reach a decision to say, well, none of these alternatives are suitable, none of them. But para 190 still leaves you with the ability,
Right. Well, we
as a
better.
decision maker, to look at meeting need in some other way. And we keep going back to the court sites process, the emerging local plan, which we know will be receiving many, many sites from house builders at the moment. We know that with a lot of confidence, I'd suggest. I can't prove it, I don't have evidence, but I know full well that will be the case.
But well, I need to go to the statement of common ground now.
Based on my experience.
No, I now need to go to the statement of common ground, which is going to waste a lot of time. But it seems to me you are seeking to backtrack from the agreement that's been reached. And
No,
that's what I'm concerned about.
I would fundamentally disagree with that. I'm not backtracking on the statement of common
We
ground.
can have some issues about, the position has always been made crystal clear. It was the position of the last inspector, which we dealt with in evidence. If one looks at alternatives, those are the alternatives that are going to be looked at. That was the agreement. No one is suggesting, I don't think my learned friend, that the scope of that paragraph precludes you to looking, even requires you to. As the last inspector to the point, he did exactly the same exercise, looked at alternatives and looked more broadly at scope for the potential on the evidence, which is what the council's done, consistently with what the last inspector did. So nothing new, and that was made absolutely crystal clear. So I think this is a slight diversion that's going to waste a great amount of time. I mean, the position is made clear in opening, it's made clear in the closings at last time, which are before the core document to this inquiry, and it's made crystal clear in the last inspector's decision. So the agreement as alternatives were quite clearly, if one's going to look at alternatives as an aspect of 190B, these are the sites you look at.
Yeah.
Doesn't preclude us from looking at other elements of 190B or addressing it in a broader way, and that's always been made clear.
Yeah, I mean, that was the way that I understood it. I mean, I'm not commenting on the word narrow in the proof, but as far as I'm aware, I've got a list of alternatives that were agreed whenever it was, way back after the CMC, and that's it.
Yeah.
Those are the alternatives I've
Yes.
got.
Yeah.
Yes, sir.
Let's,
So, yeah,
let's leave it on that.
and I mean, the short point is, whatever may or may not come out from the law, if it's ever published, or whether there's a new call for sites, which there might well be, as you said yesterday, or whether we get to a local plan in months or years' time, we haven't got any evidence on any of that, have we? Nothing.
Don't have evidence, no.
No. Okay.
Well, I mean, if it helps, when, as I'll have to in some way or other, when in my decision I look at alternatives, I'm going to be looking at these alternatives that we've listed.
Mm.
And I can tell you now, I'm most unlikely to go off on flights of speculation as to what may come out of a local plan
Well, thank you.
or any
That's
other
helpful.
matter. These are the alternatives I've got.
That's helpful, sir. Thank you. Now, can we then just turn, please, to the last few things on alternatives, please? I think in 109, if you look at your paragraph 9.11 again.
Yes.
There's one thing I just wanted to pick up with you. You've gone through the principles in 9 to 10, and you reached some conclusions in 9.11. But you do mention, I can't see the reference now, and I think you dealt with this in chief actually, that the first part of B is the cost of developing outside the designated area. And I think it was put to you that obviously we're not running a case on cost. And you obviously agreed, and we're not running a case on cost. But can I just understand what that really means in this context? Because, I mean, if you're going to build housing, it doesn't matter, does it, in cost terms, whether it's on a field in the national landscape or a field outside the national landscape. The cost's going to be the same, isn't it, for building the housing? Yeah.
Potentially, yes. Potentially, yes. Yeah.
I mean, the only thing that would be different is, I mean, obviously, if you're going to build on brownfield land, often the costs are different, aren't they?
Can be, yes.
Yeah.
Yes.
Okay.
In case, yeah.
All right. So I think we can push that one aside. Thank you. Now, can I just understand this from you? If you go to your table, at the end of your table in your proof, so this is page 29 of your proof.
Yes.
What I just need to understand from you is, suppose the inspector decides that he's going to go with the approach that I'm advocating and that the two previous inspectors that we've been discussing took, and that you have to find sufficient units to meet the full unmet need of the area. At the end of your table, if we included all of the sites as alternatives, and in fact, you knock some of them out, as we've just discussed, the last four that are in the national landscape. But even if we included them all, they come to 844. And 844 doesn't meet, does it, any of the figures that we've talked about for the needs of the borough, correct?
Correct.
Okay. Thank you. Now, I just wanted to understand with you, if I could, I got a bit confused by your table and your figures, and I want to make sure that I've understood this. I think there might be, we'll come to it in a moment, some errors in the calculations, but you gave us some revised calculations yesterday, didn't you, about the number of units that you say actually come out of this process. Is that right?
Yes.
Remember we looked at that yesterday?
Yeah.
So I just wanted to make sure I understood what we'd got to, because I suspect you've still got a note of what you said, but as I understood what you said, we were taking off a number of units, weren't we, for the ones that are in the national landscape. So I think, is it 15, 16, 17 and 18 that you wanted to take out because you believe that they're worse than our site. Is that right?
But in a broad assessment, yes, it's broader than.
In a broad
It's not just a
assessment.
landscape reason for taking those out. I think
No.
they're poorer alternatives, all four of them.
Yeah.
Sites 15 to 18 in my
And how
view.
many units do you say that removes from the calculation?
The capacities of the sites were agreed. I think they were agreed through the statement of common ground in the list
Yes.
of initial. So we've got no disagreement on the capacity. And when you calculate the agreed capacities of those four sites, I got to 170 dwellings. In total
170
from those
dwellings.
four sites, 15, 16, 17 and 18.
Yeah, so that's 30 plus 30, 60 plus 30, 90 plus 50, that's
Plus
140, isn't it?
No, I've got my maths wrong.
Yeah, I think you got your maths wrong.
Yes, sorry. Yes, you are
But
correct.
also, I think
Apologies.
there's another mistake here, because if you look at your, can you get out your, what's called your appendix 7, please?
Yes,
And this is where I started to kind of lose where we were on these figures yesterday, and I wanted to understand it because I think some of the figures that you've given for the dwelling capacities in the table in your proof are wrong, and I think that you've got them right in your Annex 5 or Annex 7 or whatever you call it, but I
Yes.
think you've got it wrong in your table, and I think that's causing some of these
Okay.
mathematical issues.
Mm.
So, for example, site 17 should be 100 dwellings, not 50 dwellings. And if you look at your site 17 table in your appendix, you've got down a total of 100, haven't you?
yes, it is a total of 100 in the
It's 100.
appendix.
And the table you've put 50, yeah?
Yes,
And then if you look at site 18, you've put down 30 dwellings, but actually for site 18, you've got 60 dwellings. So you've got that figure wrong too in the table in your proof, but right in your appendix.
yes,
Now, if you add all those up with the right numbers, I think it's 220, sorry. So if you look at if we correct it in the way that we've just gone through and done, so we've got 30 for site 15, 30 for site 16, that gets us to 60. We've then got 100 for site 17, that's 160, and then we've got 60 for site 18, so that takes us to 220, correct?
yes,
So we're minusing 220, not 170
from 844.
from 844. Is that right?
Yes.
Yeah. Now you then took off another number, and I think Mr. Cosgrove put to you that we take off a further 40. Now I think between the two of you, you may have referred to the wrong site, but can I just ask you, the site that you were deducting from for, if I can understand that, was the site which has recently obtained planning permission, Old Grove, is that correct?
Right. I think we were talking about the same, site, and I think the difference of the numbers was,
Well, no,
in the overall, in the table, we had agreed 40,
yeah,
same in the common ground, but I think the planning approval was for
Yes.
18.
yes.
So I think
but-
that's the difference.
Yes, it is. But you see, when you were asked to do the calculation by Mr. Well, first of all, is it right that that's the site we're talking about, Old
That
Grove?
is the site, I believe
Right,
so.
okay.
yes.
And secondly, when you went through this with Mr. Cosgrove, you took off 40. But that's wrong, isn't it? Because there's only planning permission for 18 if you're going to take them off. I mean, I'm not sure I understand the logic of why we crossed them off, but let's just take the logic of that for now.
Yes, I think what happened there was that we had 40 in the table, so if we were taking that off, we were going to take off the full 40, but going back, it's the planning permission that's the important point.
Yeah.
It's 18.
So we take off 18.
I agree
So
with that. yeah.
844
Important thing.
minus 220 takes us to 624. That's
Yes.
correct. And then we take off a further 18.
18.
Is that correct?
Yes,
So what's that leave us with? 606. Is that correct? Yeah. I think
606. Yes.
606.
Yeah.
Okay, so that's the figure that you put to the inspector as a sort of possible total outcome from your assessment of the
Yes,
alternatives.
almost 6 times the capacity of the site.
Yeah,
Yes.
and a tiny fraction on any view of the need for the borough. Yes,
Yes.
yes. Good. Now, can we just explore these sites, please, quite quickly? I don't want to spend a lot of time on this. Right, first of all, go back to the beginning of your table. I think what you're going to need to have to really make this work is you're going to have your table in your proof. We're probably going to have your appendix 5 or 7 to hand. Yeah. And then I think we probably want to have, don't we, Mr. Collins' equivalent, which is his proof at page, I think, 68 to 69.
I wonder if this might be a good time for a break, but while we
Yeah.
get the documents out, I don't know.
No,
I'll let
that's
you,
fine.
but just-
Yeah, I think it's a good time for a break, and also I'm going to start running out of screens here.
Yes.
I don't mind which one, but is there an unmarked copy of any one of those 3 documents that I can have when we go through this exercise?
Yeah, I'm sure there is. Is there?
So I've probably got my proof in my car unmarked.
Yeah, I don't mind which one it is. It's simply that trying to look at 3 documents at once, I'm going to run out of space.
Yeah.
Yes. So
Could you list them again, actually? So I interrupted everyone and I didn't take a note of what documents they were, but.
So it's first of all Mr. Johnson's proof at page 24 onwards.
Yep.
Secondly, it's his equivalent appendix, which is 5 or 7.
the one that we were just looking
The
at.
one we were just
Yes.
looking
Yeah.
at, yeah.
And
And
then
then
there's-
there's Mr. Collins' proof, which is pages 68 to 69.
And just to assist as well, Mr. Inspector, if anything like me, it always helps to have a fairly simple location plan in front of you as well. And if you did want to have that, that's Appendix 8.
Ooh.
But if you just want to have a plan in front of you with each one.
Let's stick
That's
with
just-
the addresses. That's enough
Okay,
for me for the
fine.
moment. Yeah,
Yeah.
if I could have a clean copy, that would be excellent. And yeah, good time to break. Where are we now? 10 to 10 past, please. Okay, let's resume. Thanks very much for the hard copies. The approach I think we're taking is looking at table 2. We've already had a quick look at it, and we've ended up with a different figure at the bottom of table 2. 844 switched to
606, but
606.
yeah, it may not be quite that straightforward, but that's where we have got so far.
I
Yes.
live in hope.
Yes, well, that's what it should be. But
But what I'm trying to achieve, I hope, in this session is get the update position based on, well, an updated table 2, if you like, because obviously that's this witness's evidence. And we've got, you can guide me through the appendices and obviously Mr. Collins' work. But what I'm trying to focus on is where are we in this witness's evidence on table 2? So that's the approach I'm taking. So what documents do I need?
Well, I think obviously we do need to look at. Let's just have a look. I think we do need the witness's proof at page 24 at the table.
Yep.
I think we do need Mr. Collins' equivalent, which is his table 6.1 on page 68, 69. And then I think the third thing that we may have to do.
Hang on, let me just get there. In the old days, I'd have put post-it notes in these places. Right, sorry.
And then the third thing we may need to dip into is Appendix 7, which is headed Appendix 5.
Yeah.
I mean, I don't think we need to dip into that too much, but we do want to dip into it a little bit.
Okay, sure.
Now, so there is there is one other document which I hope we don't have to go to, which is the Statement of Common Ground, which has got the alternative set out.
Yes.
And I hope we can avoid that, but I'll check over the next couple of questions. We should be able to avoid it, I hope. So let's see. So Mr. Johnson, can I just check something with you to start with? If you look at Mr. Collins' table 6.1,
Yes.
he has set out the number of dwellings from each of the 18 agreed sites. And he's taken these directly from the table in the Statement of Common Ground. And he gets to a figure of 822. And we've checked this and rechecked it. That is actually the correct figure, 822. I'm not entirely sure where the 844 in your proof comes from. But can I just run through why that's occurred with you? And I think it's quite, well, I was going to say it's quite straightforward. That might be an exaggeration, but I think it can be explained. But first of all, do you just want to check yourself, Mr. Johnson, that it's correct that Mr. Collins has, in table 6.1, accurately transcribed all of the individual numbers of dwellings that we've agreed in the Statement of Common Ground and the total that's been agreed? So I don't know if you want to look at yourself just to check, because I mean, then we don't need to go back to the Statement of Common Ground. But the Statement of Common Ground, if we want to look at that, is in NID 3.10 or 11, I can't remember now. Let's have a look. NID. NID 3. No, hang on, it's on NID 4. NID 4 point, yes, 4.11. And there's when you get to that, there's a, yes, this is this is table in Appendix 2, the alternative sites list. Yes, it's on electronic page 30. If you just want to check, Mr. Johnson, I think it's right. I'm happy to be corrected that Mr. Collins has fully accurately transcribed the numbers between the Statement of Common Ground and his proof. Yours hasn't done that, and I'll show you why in a moment. But just to check that Mr. Collins has done it correctly, yes.
Yes, I've spotted where the
I think
difference is as well. We
okay.
spoke about that earlier.
So
yes.
let's just proceed on the basis Mr. Collins one accurately transcribed it. And in terms of where things have gone wrong, I mean, I think there is an overall arithmetic error on the 844, and I've given up trying to get to how you got to that. But let's leave that aside. The differences, please, just so we can be clear about this, is site 4, Old Grove, you've got it down for 40 dwellings, but it should actually be 18. That's what we agreed, wasn't it? 18,
Yes,
not
that's-
40.
Yeah, we're going back to that point
Yeah.
we discussed earlier.
Yeah. So actually, on that basis, one strips out the whole 40 from your table. But anyway, leave that aside for now. Leave that aside for now.
A bit ac-
The other error, I think, which I've spotted, is on site 13. Site 13, you've got 25 dwellings, and we've agreed 15.
You're referring to my table in my proof,
Yeah,
but
yeah,
yes,
yeah.
the appendix is correct.
Yes, the
in my
expense
proof,
appendix is
yes.
And
So-
then,
so
and then
I've
we've talked about
referred to the
17,
appendix,
yeah, we've
that's-
talked about 17 and 18, where obviously you had incorrect figures. You had only half the number of units for 17 and 18. But I mean, where we get to, without sort of getting into all the things, I mean, ignore your table for now. If you go to Mr. Collins, we know that 822 is correct, don't we? Mr. Collins 822 is correct for adding up all of those sites. I mean, do you want to check that, or?
I haven't actually, because there's not a total in the statement of common ground, is there? But,
No, well, why don't you take my word for it for now? And if I'm wrong, it can be corrected later, but I'm pretty sure that does add up to 822. Now, if we then do it this way, if we take off the 220 from sites 15, 16, 17 and 18, and we take off the 18 for Old Grove, because that's how many are in the table and that's how many planning permission were granted for, I think, help me if I'm wrong on this, I think we get to 584. So I think your actual figure should be 584, not 606, as we discussed earlier.
okay,
Are you happy with that?
yes, I am.
Okay.
Yes.
Good. Now, can we just try and briefly discuss these sites? And I don't want to spend a long time on them, because in a way, given the contrasting positions, I'm not sure how material it really is. And I explain why, because obviously your position is, as long as there's any site that can accommodate 111 units, that's preferable, there's an alternative, yeah?
Yes.
So, I mean, you know, we could, for example, couldn't we look at one site in particular, which I think you've drawn attention to, which is the, so you say, don't you, in your proof, there's one site that could accommodate all 111 dwellings. Yeah.
Or equally a combination of
Yeah.
more than one.
Yeah, it
Two
could.
sites, 3 sites, 4
Exactly.
sites. Yes.
But so in a sense, you know, it doesn't really matter, because if you're right about that, then that's your answer. Obviously, but if I'm right, then it doesn't really matter either in one sense what the alternatives deliver, because your 822 doesn't even meet 1 year of standard method need, does it? Nowhere near, in fact. Correct?
No, it just provides an alternative to the appeal site
Yes, but if you're wrong on that approach,
several times over that.
yeah, and a fraction of 1 year of the need, if I'm right, correct?
Yes, but
Yes.
we're going back to that.
Yeah.
that debate we had
But that's
earlier, aren't
why
we?
I'm just
between
trying to
A and
explore
B?
how important it is for us to actually look at these individual sites. But look, okay, look, let's just very quickly look at them. So I just want to understand with you, on a number of these sites, if you look at Mr. Collins' table, page 68, he's got 6 of them, hasn't shaded, because those are ones that we don't agree should be in the list at all, because we say they're already allocated, so they're already accounted for in the supply. And therefore, to say they're in the supply, but then also alternatives, we say it's double counting, because they're not meeting the gap between the supply and the need. Now, I know you don't agree and you wanted to include them, but that is the position. There's a dispute between us on those, yes?
I fundamentally disagree that they
I
should
know
be
you do.
excluded. Yes.
I know you do. But, I mean, they are in the supply, aren't they? That Mr. Neem has calculated as existing supply.
They are in the supply, yes.
Yeah.
Yes, but
So
there's
they're in
still
the
alternatives to the
Oh, I see.
appeal site.
But this comes back to our basic debate, because they're not alternatives if they're not meeting the full need, which is my position, and you don't agree with that position,
No.
correct? Right, okay, fine. Well, I don't want to have that debate again, so let's just park that for now. So I'm just going to look at those sites, but you realise in me addressing these with you. I don't actually agree they should be in the table at all, but I'll address them anyway. Right, now, just on that first site, Site 1, Hazelmere, I mean, just so the inspector appreciates this, this site is currently, is this right, operating as the Waitrose car park in the town, is that right?
Yes, it's the adopted local plan allocation. Yes.
Yeah. So it's currently operated as a car park in the town for Waitrose, correct?
I think so. Yes, it's all
Yeah.
public. I think so to the public.
Yeah, I think you can park there if you go to the town centre.
Yes.
People use it for Waitrose, but actually any town centre user can park in the car park.
Yeah.
And it's in mixed ownership, isn't it? Council owns some, but other parts are owned by other people, correct?
Yes, council part owners. Yes.
Yeah. And is there any evidence of land assembly or a land agreement?
Not at the
No, not at this
current
time.
point in time. No.
And Mr. Neame, who, as we know, has spent many years looking at all these kind of sites, because I think at various times they've been in and out of the 5-year supply. He says that this site's been talked about for redevelopment for about 20 years. Do you know if that's right or not?
I don't know if that's right.
No.
I know it's an adopted local plan allocation,
Okay.
but I don't know if that's right.
And then can I just ask you this? All of your sites that you've got in here, well, not all of them, but quite a lot of them are not on your own account of deliverable within 5 years. They're deliverable within a longer period, either 7 or 6 years, correct? I mean, there are a couple that are 5 years, but mostly they're 6 or 7, correct?
Yes, in my appendix, so you'll see how I've produced a phased delivery, if you like, through the years,
Yeah.
7 years ahead.
Yeah. Now, the reason you've done that, as I understand it, you explain that, don't you, I think you explain that in your proof at paragraph 910 again, Roman 3. You say the alternative sites have been subject to broad brush assessments to whether they are developable to ensure fair comparison with the time frame for delivery of the appeal scheme, which I understand would extend beyond 5 years. So you've extended, haven't you, the period to look at whether something's going to come forward beyond 5 years, because you take the view the site would take longer than 5 years itself to come forward.
Yeah,
Is
it
that
goes
right?
back to my like for like comparison.
Yeah,
Yes.
okay. Now, I mean, your basis for saying our site couldn't come forward earlier than 5 years, as I understood your evidence in chief, is essentially that Litchfield report that you referred to. Is that correct?
Yes, I have used that. Yeah.
You have used that.
Yeah.
Now, can I just ask you a couple of things on that? I mean, obviously, our position is that the site could come forward quicker than that. But the Litchfield's figures are deliberately and clearly stated to be averages, aren't they?
Yeah, they apply mean or median.
Yeah.
Median, isn't it? Yes.
Which means that within those groupings, some of those sites will have come forward much quicker than 5 years and some of them much slower, correct?
Yes. Yeah.
Right. So it is possible that a site that gets outline planning permission can come forward quicker than those periods that are set as the averages.
It is possible, but
Yeah.
I think that the reason why there's flexibility here is that it refers to planning approval period.
Yeah.
Now that's very different depending on the nature of the planning application. So you could have a full
Right.
application that would come forward.
Yeah.
That you did typify a period of time, but then an outline is obviously very different, isn't it? Because you have 2 stages, an outline process, in this case, an appeal process, after which there's a reserve matters process
Yeah.
as well. So I think that's why there's this range allowed for in the
Yeah, but I mean,
Savills report.
by definition, if it's an average, some sites come forwards quicker and some slower.
Yes.
Yeah. And then the other point is that obviously Litchfields, for the purpose of analysis, have broken down into categories so that if you're 99 units or less, there's a lower average period. And if you're bigger than that, it's a slower average. But I mean, that in itself, I mean, it's obviously useful to have that for analysis. But I mean, it's an arbitrary line in a lot of ways, isn't it? Because I mean, I think it goes, doesn't it? We can look at the Litchfield report if you like, but I think it goes up to 99, and then is it 100 to 499, the next category?
Yes, it is. Yes.
Yeah. So obviously you've put us, because we're 111 in that second category, but we're actually right at the lowest end, aren't we, of that second category?
Yes.
We're closer to 99 than 499 by quite a way.
Yes.
Yeah. Okay.
Yeah.
And I mean, you've seen also Mr. Collins in his proof attached, didn't he? It's electronic page 281. It's the Elvia Homes letter, which is Appendix 6 to his proof, explaining that they are interested in taking the site, and explaining that they think that they would be able to deliver the site much more quickly than the Litchfields report refers to. And they're obviously building currently on phase 1, aren't they?
Yes, they are, yeah.
So they could roll over into phase 2 if we obtain planning permission.
Yeah.
And their view is they could build quicker than
If,
5 years.
that's right,
Yeah.
if they were the developer.
If they were
the
the
developer,
developer,
yes.
yeah, okay.
If, yeah.
All right, but I mean, leave that aside because, you know, what you've done is you've actually looked at sites over a period longer than 5 years in any event. So that's fine. Okay. So I don't want to talk about site 1 anymore. Can we move on to talk about, please, a couple of the other ones. So if you go to site 2, this is one I need to spend just a tiny bit more time on. There's been a lot of discussion about the Royal Junior School. I mean, we know it's an allocated site, so we've got that dispute. That site is in the national landscape, correct?
Yes, it is, yeah.
So
It's
it would have-
allocation within the national
Allocation,
landscape,
but it would
yes.
have to satisfy the exceptional circumstances test because that applies even to allocated sites.
Has the weight of an adopted allocation
Uh-huh.
behind it, yes.
But you're not denying, because it's absolutely crystal clear, isn't it, from the Wealden case and other cases, that even if you're an adopted plan allocation, you have to satisfy the exceptional circumstances test at the development control stage.
No, I wouldn't disagree with that, but obviously the plan has primacy, doesn't it? So the plan you go to first, it's the first consideration.
But I mean,
You
that
go-
would
go to
include-
the allocation first, yes.
that would include consideration of 190B. Is there an alternative site on which you could deliver?
I'm not saying we preclude that. That is a material consideration,
Right.
of course, and obviously the
Okay.
local plan inspector had been through that consideration at the local plan
Okay.
preparation stage, leading to its allocation.
Now, I just want to understand your position on this site because you suggested in your evidence in chief that you had some knowledge of this site because Carla is one of your clients. You're not acting for Carla on this site, are you?
No, I'm not, no.
No. So just in terms of your information on this, in terms of what's in the public domain, there's an outstanding objection from Natural England, 2023, not removed, correct?
Yes, that is correct.
There's an outstanding objection from Sport England, not removed, correct?
It is correct, and I can provide a bit of background to that if that would be helpful.
Well, I just want to understand the factual position, first of all. That is the
Come back to that, but
position
yes,
on
that is
those.
the fact.
And then thirdly, you've identified that they've come up against another issue in the course of the application, which is they had one of the buildings spot listed. And so
Yes,
they're
they
now having to deal with that issue as well.
Yes, it did, yeah.
Now, your suggestion was that you considered that what was really holding this up was the heritage issue that emerged rather than the SANG issue. And you referred to a SANG solution that combined on-site and off-site solution. Now, just so I can understand this, are you saying that there is a SANG solution that's been put forward other than the one that's part of the application? Because the application has a proposed SANG solution that is on-site and off-site,
Yes.
and that is what Natural England have objected to. Are you saying there is some other plan that's not in the public domain that has been put forward?
No, I'm not saying that. I'm saying that the objection from Natural England is in relation to the requirement for further information. And they refer to a SANG management plan, and they refer to visitor survey information being required. So I think there is a physical solution, but I think there's a request for further information and clarification.
But
from
isn't the
Natural
off-site
England.
part though, is that not on National Trust land?
Is this the Nutcombe Valley
Hmm.
site, I think?
So, I mean, I'll tell you why, because when we heard what you said about Carla, so we asked Carla what was going on. Right now, they say that they have got a Natural England objection, and the application is stalled, and it's been stalled for some time, both on the Natural England objection, but also on, you're quite right, the heritage issue, because they're having to look at reduce the number of units.
Well, you've done better than I have, because
Okay.
the Carla, the gentleman I know at Carla who's leading on that application is on annual leave
Right.
at the moment this week. But certainly the situation as I understand it, and this is also in discussion with the case officer, council's officer dealing with the application, it is the spot listing that has delayed, and now Carla are having to revise and amend their plans.
Reduce the number of units because you've now got a listed building.
No, I don't think that is the case, and those amended plans are imminent, I'm told by the case officer.
Well,
That is his understanding.
also, I mean, we understand that we've written, it's attached to Mr. Collins' rebuttal. We made a Freedom of Information Act request to the council for any information about any developments in relation to this site, and we've had no substantive response. So in terms of what's in the public domain, we have an outstanding Natural England objection, we have an outstanding Sport England objection, and we have a new heritage issue that's emerged in relation to this site.
But what I would say in response to that is that for a site of this scale, and I deal with many sites of this scale and much, much larger, it's fairly standard that you will have holding objections on complex sites such as this, Sport England, Natural England, and so on, and they tend to be holding objections that you will ultimately work through. And having read those objections, they're more requests for further information and clarification.
Well, that's absolutely not our reading of the Natural England objection. We understand it to be an objection in principle to that proposed solution as being unsatisfactory. Now, I think what we need to do is I'll need to check whether we've got the Natural England objection letter in the core docs, but if we haven't, I suspect the inspector should probably have a copy of what Natural England objection actually is. But let's not debate that any further. I just wanted to ask you this. I mean, if there are outstanding concerns by Natural England that this SANG solution that's been put forward on the Royal School is not acceptable, our site, if it were granted planning permission and it was able to, as it can even at 9 hectares, provide additional SANG capacity on a strategic level to mitigate sites in the town, could provide the mitigation for this site, correct?
It would be one option open to the applicant, yes.
And there's another important part to this, isn't there? That what we've agreed to do under the Section 106 is we've agreed to make the SANG available that's in excess of what we require at an extremely low rate. So it's set at a very, very low rate. We'll discuss the detail of that in the Section 106 session. So there's actually, it's not just that we're offering a commercial kind of solution, we're actually offering through the 106 a really below market rate solution in relation to this. So it would be an option for them. It would be an option for them. Now, that's correct, isn't it? It would be an option for them. Yes?
Yes, it would be an option.
So I think we have got the Natural England letter in the core docs. So it's CD 15.1. CD 15.1. Natural England's objection to the Royal School. So you'll see on the second page, mitigation, SANG.
Yes.
Require a full SANG management plan, which must detail how it meets the necessary specification.
Yes.
Assessed on a unique basis. The understanding the allocations for 90 units, with the application proposing a further 11. Overall site area 9.68. Unclear how much this has been retained for the on-site. In our opinion, the on-site SANG does not meet the specification for an effective standalone site. Continue to express our views on this, leading now to the proposed additional mitigation via access improvements in Nutcombe Valley. So that's the off-site part, is it?
That's what I mentioned. Yes.
Yeah.
Yes.
Neither the on-site SANG or the proposed, and look at the inverted commas, SANG, so not accepted to be SANG, through Nutcombe Valley, have demonstrated how they meet the necessary SANG criteria. Natural England recognise the access plan. However, these works do not demonstrate their potential uplift to be able to access how they can unlock the proposed development of the Royal School. Then there's a reference to absence of visitor surveys.
Yes.
Further information to understand how these packages, one on and one off site, would be able to meet those requirements. Now, I'm not aware, but you might be able to help me on this, that there's actually ever been a substantive response that's satisfied Natural England on all of those points, has there?
In terms of responding to requests for those further details, clarifications, no. And the reason for that, as I believe, I don't know, I've got this slightly secondhand, but it's from the case officer, that the focus has been on resolving the spot listing on the school building. And I think that's what's really delayed this application.
Well, okay, we don't agree on that, but there's clearly an outstanding Natural England objection, and we haven't seen any information to satisfy that so far. correct?
That is correct.
That's
It's
correct.
requested
Right,
further
good.
information. Yeah.
Okay, just briefly then on site 3, please, the Fairground Car Park, Way Hill. That's another site that's an existing car park, is that correct?
Yeah, another adopted allocation within the settlement boundary, yes.
Yeah, and as I understand it, is this the one that's correct? Is this proposing to remove the car park or retain it? I think you explained this, don't you, in your In your
Well,
table.
this is, again, a council-owned site.
yeah.
And I think the idea is to redevelop this.
Right, so it won't be a
I'm-
car park anymore.
No, I'm told there's an application in the council's programme to be submitted at the end of 2026.
So submission and end of 2026. I mean, the only thing in the public domain that we know of was that there was some funding approved for a high-level assessment of the site's potential for development in April 24, and that's the last thing we've heard of in the public domain. Is that correct?
Sorry, what was the date of?
So April 24,
April
there was an
24, sorry.
announcement that they'd funded a high-level assessment of its potential to be developed. That's the last we heard of it.
I believe so.
Yeah,
I think
okay.
I've read that as well.
All right, and then this site is directly opposite, isn't it? The youth campus site, is that right?
I'm not aware of youth campus site.
Yeah, the youth campus site.
I'm not sure how that affects the
Well,
development potential or the likelihood of that.
well, I'll tell you what it
Forest, but-
affects. Obviously, I'm trying to understand how your LPP2 works, and as I understand it, you know, if you're below 20 units, you don't require SANG or any mitigation, as far as I can see. And then if you get to above that, you need some mitigation, and if you get above 50,
Yes.
then you need some other mitigation.
Yes.
I mean, if you have two sites that are going to be developed right beside each other, and they together amount to more than 50 units, how does that work under the local plan? Do you aggregate them, or do you salami slice them up?
I don't think they're viewed as the same site. I don't
Okay.
think they're as a single contiguous.
No.
They're not
Well,
a part of a contiguous site either.
and just-
They're separate sites.
Just on that, I mean, the requirements of the habitats regulations can't be overridden, can they, by what a development plan says?
No.
No. Okay, good. Right. Okay. Is there any developer on board on site 3 for the fairground?
I'm unaware of that.
Unaware of that. Okay. If there is a requirement for mitigation for this site, I don't know whether there is in terms of SANG. There will be, given it's Hazelmere. Again, our site, if mitigation was required, could provide that, couldn't it?
Or also, or a Heathland infrastructure project, a HIP, which is allowed for
Yeah.
under policy as an
Okay.
alternative to
All
SAF.
right.
Yes.
Old Grove, we've heard about, and the planning permission was for 18 units, as we discussed. Can we just look at one point, please, on that? We
Yeah.
put in, didn't we, I think we put in the officer report in relation to this scheme.
Yes.
13.24, so NID 13.24. Yes, it is the last thing that's gone in. Have you found that yet?
Yes, I have it here. Thank
Okay,
you.
good.
Sorry.
So I was hoping that you could go, I think it's page 13 of the document.
No, I've only got I'm using the paper copy and it's not paginated. If I go to the electronic copy, is that easier?
Well, hang on a minute. Let me just see. It's section 15, halfway through, about halfway through.
Section
You see
15.
there's a heading effect on the Wealdon Heath and East House.
Yes, I have. Okay. Thank you.
So I just want to understand how this works in terms of this. So it says here, so the site's located within the Wealdon Heath's SPA buffer zone, as well as the East Hants SPA, would result in an increase in people permanently on site. LPP 2, paragraph 7.14, describes Natural England's advice that all net new residential development between 405k the Wealdon Heath SPA of less than 20 dwellings would be unlikely to need mitigation. Factually, that is the case here, although it's important to note that this portion of the site forms a wider allocation of 40 dwellings. Natural England consider that the 18 dwellings proposed by the application in combination with care home would result in the site having over 20 net additional dwellings, thereby requiring mitigation.
Yeah.
They are of the opinion the proposal partitions off the Grove site, and mitigation is therefore required to ensure this application does not result in a net adverse effect on integrity. Because the applicant's case is that parts of the allocation have come forward at different times because the site was disused. Officers raised no objection to the site coming forward at different times. And then this, however, it's important to ensure mitigation is provided as soon as the 20th dwelling is applied for, likely to be part of the second phase of development comprising the remaining 22 dwellings. The commitment to mitigate for all dwellings in the allocation is considered to resolve Natural England's concern that the site is being partitioned to avoid mitigation. This can be secured through the Section 106 agreement. So although it's been granted on the basis you don't need mitigation because this is below 20, what it's saying is that the moment you get to 20 on this site, you will need to have mitigation, and for all of the units, including the 18 that have already got permission. That's what's being said, isn't it?
Yes, and that's in line with policy that requires some form of mitigation.
Okay.
Yes, which can include HIPs.
Or include a strategic SANG. Yeah?
Sites of this size, 20 to 49.
Yeah. It could include making use of our SANG, which is going to be offered at a particularly low rate, correct?
It wouldn't be beholden to that, but it could do. It's an option, certainly, under the policy. Yeah.
Okay, fine. All right, now can I consider together sites 5 and 7 very briefly? Those sites, so former Longfields Care Home and St Nicholas Junior School, Cranley.
Yes.
Now these are, I think you said in evidence in chief that one or other of these is allocated, but they're not allocated, are they? They were proposed to be allocated, I think in the Cranley neighbourhood plan, but neither of them are in fact allocated, are they?
This is site 5
And
and
7.
7.
Yeah.
Previously proposed.
Yeah, previously
Yes.
proposed, but they're not allocated, are they?
No.
No. Okay, fine.
No.
Now, just in relation to that, the school would have to be, I think you tell us, don't you, in evidence, relocated, correct?
Yes, it's a previously developed site. Yes, there's a school on the site at the
Okay.
moment. Yes.
All right, thank you.
Brownfield.
Thank you. And I think it's correct, isn't it, that one of them, Site 7, has a previous refusal of planning permission for, I think, was it 91 units? 91 units in 2019, is that correct?
Yes, and I think the reasons for that were there's a design-related objection, loss of trees, absence of a legal agreement, secure delivery, unnecessary instruction, and so on.
All right.
But yeah, as I say, it's a brownfield site here, isn't it? And it's
Yeah.
it's not particularly constrained. Flood zone 1.
Yeah.
Within the settlement boundary.
Yeah. Okay. And then Site 6, which you've included, which we dispute, for 5 units. I mean,
Yes.
our methodology that has led to the creation of this list generally excluded sites under 10 units on the basis that there's already a windfall allowance provided for in Mr. Neam's trajectories. You haven't put forward any other alternative sites below 10 units. This is the only one, is that right?
Yes, this is the only one that's in the
Right.
agreed list. Yes.
Okay, fine. Okay, Site 8, Old Park, Farnham. Is this the one, I think you explained, don't you? If we look at your appendices on this one, see what you say about it. You refer to there being a planning appeal made by Gleeson. That was an appeal for 83 dwellings, I think, which the council refused. Is that correct?
Yes, that is correct.
And they fought an appeal relatively recently on that.
It is in February. Yes.
Yeah.
I think the inquiry is February.
Yeah, and that there's no decision yet, is there?
No, not I'm
No.
aware of, no.
And the reasons for refusal included, didn't they, that it was in conflict with the Farnham neighbourhood plan?
Yes, as well as being outside the defined settlement boundary,
Okay,
yes.
fine. Good. 9, Lower Weybourne Lane, Badshot, Lee. So this is a site that, I mean, we agree, don't we? If you look at Mr. Collins' table, we give this a lower landscape sensitivity or score than the appeal site, correct? We give it 3, and we score our site, I think, as 4. So you'll see
Oh,
that
I see.
yeah, you
Yes,
see we
sorry.
actually recognise that point here. Just on the history of this site, I mean, I think you've referred to there being previous history to this site. I mean, as I understand it, there have been 3 inquiries on this site and a High Court case. Are you aware of that?
I wasn't aware of the High Court case, no.
No, but there have been previous appeals, 3, I think. Is that correct?
I think so, yes.
Yeah. Okay.
Yeah.
And this is the only site, is it? Correct me if I'm wrong, but of all the alternatives, this is the only one that you say could accommodate all 111 units that we're proposing. Is that right?
I think it's the only one that could accommodate the whole of the 111 on its own, yes. And I think Mr. Neame has picked up on this as one of the potential sites. I think he pulled out 3, didn't he, in his statement that potentially could come forward.
Yeah. Okay.
But this is one of those, yes.
Right. Okay. Now, the next site, site 10, land east of Hedgehog Lane.
Yes.
This site, this is partly in the national landscape?
Yes.
Yeah.
So, yeah.
Okay. And you say it's got a medium to high sensitivity of landscape. We actually rate it as having a higher landscape sensitivity than the appeal site. But it is on any view, isn't it? Similar to us being where it is, it's in a national landscape, at least in part. So high sensitivity.
In part, yes.
Yeah. Okay. And in terms of the, I mean, obviously we've got the where we get our scores for landscape from is you have to go to Mr. Smith's proof, and he's based himself on the work that Mr. McDermott has done of developing scores for each of the alternative sites that range between 1 and 6.
Yes.
In terms of the input that you've had on landscape for your assessment, when we look at your appendix 5, if you just take an example, your first site, what you've got is that Mr. Petro has given you a landscape value, susceptibility and sensitivity for each site.
Yes.
That is the full input.
Those were his additions, yes.
That's the full input, yeah. Okay. And I asked him about how he'd undertaken that exercise, so I won't go any further in relation to that. Now, can we just move on with the sites then, please? Site 11. This is a site which, again, I think both you and we recognise has a medium to high, we say high landscape sensitivity, correct?
Yes, I value medium, susceptibility medium high, sensitivity medium high.
Okay.
Yeah.
Thank you. And then site 12, again, you recognise as having a medium high sensitivity, and I think we say it's a sensitivity of 5, which means it's more sensitive in our view than the appeal site, correct?
Yes, and that's where we differ, yes.
Okay. And then site 13, Petworth Road, Hazelmere. Again, being in Hazelmere, this would potentially, look at its size, 21 dwellings, so it would need some form of mitigation, correct? On SPA grounds?
Yes, would need,
Yeah.
yes.
Okay. Mr. Collins says there are also issues about trees subject to tree protection orders. Do you know
Yes.
about that? Yeah.
Yes.
Okay.
13.
No, I said 21. Sorry, which site we're talking about? Sorry.
30.
Oh, sorry. Yes, sorry, site 13. Yes, number is 15. Sorry, 15. Sorry. Yes, no, fair enough. Site 15. Do you know who owns that site? Has it been put
Site
forward?
15?
13.
Sorry, 13. No, I don't, I'm afraid.
You know, has it been put forward? Has been any planning application for the site?
There has I think there was a dismissed appeal
Dismissed appeal, yeah,
on
good.
that site, yeah.
That was in 2018, I think, yeah. Now, site 14, that's the one that was withdrawn recently, correct?
Yes, that is correct, yes.
Yeah. And I think you again say medium high sensitivity, so it is in the national landscape, isn't it, this site?
Yes, it is, yes.
Yeah.
And as I mentioned, the reason for the withdrawal was an ecology survey requirement that couldn't be fulfilled this survey season, so likely to be undertaken next
Well,
survey season.
okay, I mean, let's just look at that briefly, please. Could we, if you go to NID 30, so NID 8, so NID tab 8.
Yes.
And could you go to 8.2? This is the officer report for the scheme, isn't it?
Yes, I have that,
Yeah,
yes.
if you go to penultimate page, page 27.
Yes, thank you. Yeah, I have that.
You've referred to the withdrawal on the basis of insufficient ecology information, and that was the proposed reason for refusal 2, wasn't it, by officers?
Yes,
Yeah, and reason for refusal 1, the proposal by way of introducing built form on the site would cause major adverse impact on the national landscape, moderate adverse on the area of great landscape value. As such, it fails to conserve and enhance their landscape and scenic beauty, conflicts with policy RE3 of the plan. So officers are against this scheme, not just on the grounds of insufficient ecology information, but they consider that it should be refused on the grounds of harm to the national landscape.
yes, because it sits partly within
Yeah.
the land, yes,
And-
partly
and-
within the national landscape.
This is a site that's also been subject to a number of previous inquiries, hasn't it?
I'm not sure of the I'm not aware of the history.
Well-
Going back, how far are you going back?
Well, you know the Monk Hill case that you, I think,
Yes,
referred to?
that's what I'm referring
That's about
to.
this site.
Yes, that's
That
right.
went to
yeah.
the Court of Appeal.
Right.
There were 2 inquiries that led to that going to the Court of Appeal.
Okay, I'm aware Monk Hill were the applicants this time round. So.
Okay, all right. So that's quite a complex one. And then I don't think we need to discuss 15 and 18, do we? Because 15 to 18,
No.
because you recognise on your own case that they are inferior. Okay.
Yes.
Now, where we get to at the end of all of this, is ultimately we come back to, don't we, the issue about whether the inspector should be looking for an alternative site for 111 units, or whether the inspector, like his colleagues on the cases we've looked at, should be looking at alternative sites that meet all of the need in the area. That's where we come down to, isn't it, in the
Yes.
end? Yeah? Okay. Now, can I just ask you to, we can move on, you put those documents away, I think. I want to ask you some questions very briefly about 190C, which deals with the effect on the environment, landscape and recreational opportunities. I mean, we've agreed this, I think, previously, but here we have to consider impacts, positive and negative, on landscape, correct?
Yes, correct.
Positive and negative on recreational opportunities,
Yes.
and positive or negative on other environmental factors, for example, biodiversity. Yes? Yeah, okay, good. Right. Let's move slightly on. Now, what I wanted to just tackle with you now is, we talked earlier, didn't we, when we talked about the environmental, the landscape impacts, about the management plan for the national landscape, yes? About the importance of the national landscape management plan, yes?
Yes.
Now, I wanted just to ask you about that, because I think we agreed that various sources, including, I think you said to me, policy RE3, emphasise the importance of the management plan in assessing whether a proposal is something that conflicts with or is consistent with the purposes of the national landscape. Yes. Now, if you look at your proof, please, in relation to this, 8.8 to 8.11. You deal here with the management plan. And I wanted to see whether we might be able to take this quite quickly because, first of all, it's correct that there are only two policies in that plan that you allege to be breached, and that's P1 and P2.
Yes, correct, yes.
And you'll remember when I cross-examined Mr. Petro, we have set out in Mr. Smith's evidence a large number of other policies in the management plan that we say our scheme is supported by and consistent with. Yes?
That may be the case, but you obviously take the plan as a whole, but.
Yes, well, yes, we do.
Decision-making, yeah.
Right. You take the plan as a whole. So where is your assessment in your evidence of all of the policies that in the management plan that provide support for our scheme so that you considered it as a whole? Where do we see your analysis of the policies that support the scheme?
I did consider those, but I haven't specifically referred to them in my proof. I
No.
think it
So
considers
the answer to my
consideration,
question
yeah.
is that there isn't anything in your proof, is there, that looks at policies which we comply with in the management plan. Is that right?
Well, that's right, but it's
No.
similarly, I'd apply that to the local plan as well. There are policies, you wouldn't refer to every single policy in a plan, would you, in terms of a proof?
No, but you would refer to the relevant ones. So we've put forward a number of other policies in the management plan that we consider are relevant and that we consider we comply with and we consider that support the scheme. Neither you nor Mr. Petro have put forward any contrary analysis in relation to those policies.
No, I've taken them into account, but
No.
I've focused on those that
So-
you are in conflict with, yeah.
Yeah, so if the inspector wants to look at the compliance of the management plan as a whole, the inspector will need to look not just at your evidence on what you say is breached, but also our evidence on all the policies that we say support our scheme, correct?
Yes.
Yes, okay. Now, if you actually look at your proof, just help me on this. You've cited in paragraph 8.11 policy P2, yes?
Yes.
Do you actually also allege a breach of P1? I know Mr. Petro does, but do you actually allege a breach of P1?
Well, the scheme is in conflict with P1 in my view, yes.
Right, yeah, but that wasn't the question I asked you, was it? I said, do you actually set out in your proof that P1 is breached and why you consider it to be breached?
No.
No, okay. Now, P2,
Yes.
respect for the special landscape character of the locality, I mean, that turns on the landscape evidence, doesn't it?
Yes, it does, yeah.
Yeah, okay. Now, there are parts of the management plan, and again, I hope we can take this quickly because I went through them with Mr. Petro. There are a number of places, aren't there, in the management plan that emphasise the real importance of and need for affordable housing in the national landscape, correct?
Yes.
Yeah, okay.
Yes.
Thank you. I will skip over those because I did go through them with Mr. Petro. Now, can I then ask you, please, just on this issue about the overall impact on the national landscape, can I ask you to go to Mr. Smith's proof of evidence, please? So that'll be if you're doing it electronically, it'll be NID 5.3.
Thank you.
And I want, so NID 5.3. There were two paragraphs I was hoping that I could just briefly look at with you. So 3.45, I think, is the first one. Yes. 3.45 on page 13.
Yes, I have that.
Yeah. So just he records here the current proposals that are ongoing for the expansion of this national landscape. And the suggestion in the most recent documentation that's available is that this national landscape could increase in size by a further 30%. And Mr. Smith points out the Surrey Hills National Landscape cover an area of 422 square kilometres. That's an increase of 30%, would be an additional 127,000 square kilometres. Based on the information we have on the proposed expansion, those figures are correct, aren't they?
It's a proposal that's
Yeah.
being consulted on, and I have no reason to disagree with those figures. I don't know.
Okay.
But as
And
I
then-
say, the status you give to that is obviously, it's just a proposal, isn't it, at this current point in time?
Yes, but it obviously would further restrain the ability of this council to deliver housing outside of national landscape if it came to fruition, correct?
And in that form as well, because the boundaries of the lines that are drawn on that plan could well change substantially, couldn't they? Which we don't know. It's just
Okay.
a consultation process.
Now, can I then ask you to go to paragraph 4.102 of the same proof on page 39?
Yes, I have that.
In the context of the national landscape, the areas on changes of the area on changes of the site, LCA 1 and LCA 2, is 5.13 hectares.
Yeah.
Thus, it is 0.0012% of the potential extension of the landscape and 0.009% of the landscape inclusive of that extension. So, I mean, on any view, the area that is being developed within the site is not just a small proportion of the site itself, but it's a tiny, tiny proportion of the overall national landscape, correct?
Yes, that is correct. But of course, you could have a national landscape that's 10 times larger, or it's just a statistic, isn't it? You've still got 5 hectares of development in a national landscape. I'm not entirely sure of how helpful that statistic is.
Well, we do have to consider, don't we, the overall impact on the national landscape as well as part of the assessment of the scheme, don't we?
Yes.
Yeah, okay. Right, can I turn to the topic of benefits, please? Go to your proof, table 3, page 36. Yes, putting the landscape on. You've got a section on the planning balance, and you have considered both the adverse impacts and the planning benefits in a table. I want to deal with this quite quickly, but can I start with the adverse impacts, please? You identify 2 harms, don't you? The harm to the national landscape, which you put at substantial, which is your highest, yes?
Yes.
And then loss of trees, which you give as significant, which is, I think, your second highest, correct?
Yes.
Now, I just wondered whether there is no case, is there, by the council that the trees to be lost have any arboricultural merit whatsoever? They're not important trees as trees. Your reliance on them is as part of the landscape, correct?
And a tree preservation order.
Yes, but that's only there because of the planning application.
It's a tree preservation order on some trees that gives them a value, isn't it, in planning terms?
Well,
so,
yeah, I'm not sure about that, but let's look at it this way, please.
well, I think if you've got a TPO tree, that's certainly more sensitive, isn't it, than a tree without
but-
TPO on it. So,
But it's been put on because of the planning application. It's standard practice these days. So I don't think that's really going to get us very far, is it? Can I just understand this from you, that you're not alleging, the council doesn't run a case, does it, that there is any arboricultural merit in any of these trees? I mean, they're all category C or U, so they've got a limited lifespan anyway, yes?
that is correct, yes.
And
Yes.
I asked Mr. Petro about this, and he was very clear that the value of the trees was as a group in landscape terms, not because of any arboricultural merit of the trees themselves, yes?
Sorry, can you just say that again? So
Well, the value of the trees, so far as Mr. Petro is concerned,
Yes.
was as a landscape feature in combination.
Yes.
There is no arboricultural value in the trees themselves as individual
I
trees.
see. No,
Yes,
I see what you're saying.
Yeah.
Yeah, I would agree with Mr.
you would agree
Petro.
with that, yes. And Mr. Petro, throughout his proof, in considering the landscape impacts of the scheme, sets out in a number of places that part of what he sees as the landscape impact is the loss of those trees on the access, yes?
Yes.
So he repeatedly makes reference to that, doesn't he, in his proof as being, I think, a quite important element of what he sees as the harm that arises from the scheme, yes?
Yes, there are a line of mature trees.
Well, they were actually all
along the
categories,
highway.
they're all category C, which means they've got a 10-year lifespan, I think, apart from 3 or 4, which are category B. So let's not go into their permanence. I don't want to talk about that. But what I just want to understand from you is, it's correct that Mr. Petro has very much taken into account tree removal as part of the landscape harm from the scheme.
Yes, I believe
Right.
it has, yes.
So can I suggest to you that you're actually double counting the impacts here, because you're counting the harm to the national landscape, which on the council's case has already taken into account, to use Mr. Cosgrove's word, baked in the loss of the trees. It's a repeated theme throughout the landscape evidence, but then you're also giving great weight to the loss of the trees as well, even though they have no value as tree specimens. They only have value for their landscape purpose. I mean, isn't that double counting?
I've given them significant weight, whereas the harm to the character and the national landscape is substantial.
That doesn't mean you're not double counting them. It just means you're giving them different weight in your double counting. I mean, I'm just going to suggest to you that you're double counting. I mean, really, we could cross out the trees one, couldn't we? And you keep your landscape substantial, because that encompasses the loss of the trees, doesn't it?
I mean, the harm to the character is obviously something slightly different to visual impact. I mean, the trees coming out, there'll be a very different appearance to that length of Midhurst Road if the trees were to be removed. And they, at the moment, they have they're quite a presence. They're very characteristic
I'm sorry, but
of the landscape character. So to take them out, I don't believe I have double counted.
well, you absolutely have double counted, and I haven't heard any explanation about why you haven't at the moment, because you've accepted that the harm to the landscape, which you've given substantial weight to, absolutely clearly encompasses the loss of those trees. It is an absolutely fundamental part of the council's case about why there's landscape harm, and yet you're then taking it into account separately for the loss of the trees. So it is double counting, isn't it, Mr. Johnson?
I'm not going to disagree with you on that now.
All right. Now, remember, we talked about this earlier. Your inclusion of benefit from all of the additional planting, which is considerable across the whole site, you take that into account, do you, under the benefits? I think we'd agreed this yesterday, under provision of open space and SANG.
Yes.
In that, we would include the provision of substantial number of new trees, etc. Would we?
Yes.
Yeah. Okay. And you give that significant but not substantial weight. Is that right?
Yes, significant. Yes.
Yeah. Now, we've discussed housing and affordable housing, and I couldn't persuade you, despite the housing needs in this area and the corporate strategy of this council, to move from significant to substantial, correct?
No, that's correct.
All right. Now, on SANG, you explained to me that your according it significant weight was based upon solely the SANG as a kind of beneficial feature on the site itself, within the landscape of the site itself.
Well,
Yes.
its function is to mitigate the impact on the SPA, isn't it? I mean, we know that, and I'm giving it significant weight.
Yeah, but you told me you hadn't taken into account, in giving it that score, the ability of our site to meet the mitigation needs of other sites. You told me you hadn't taken that into account yesterday. Is that right?
Because the reason for that, just to add a bit of context, is the way the 106 was drafted didn't actually deliver that additional SAG.
Okay.
And the latest draft, which I've shared today, I still don't, as I understand it, still doesn't achieve that either.
Right,
That's for something for the two solicitors to work through.
No. Okay. Well,
that's the instructions I've been given.
That's wrong and wrong. So let's just explain to you why it's wrong, shall we? Page 78 of Mr. Collins' proof. This is a misunderstanding by you, and quite a fundamental one, I might add. So let's just look at it, because it's very important that you understand this part of the scheme, given you haven't given any weight to this. Page 78.
Yes, have that.
So there's two paragraphs we need to read. 7.6, for completeness, based on the standard SANG capacity of 8 hectares per 1,000 new residents, a SANG of 9.69 hectares would provide mitigation for 504 dwellings, albeit only within a 2-kilometre driving catchment, rather than the larger 4-kilometre driving catchment associated with a SANG of 12 hectares, assuming an average occupancy rate of 2.4 people per dwelling. So on this total capacity, up to 161 dwellings will be reserved by Scotland Park phases 1 and 2, leaving a net capacity for 343 dwellings. This would comfortably accommodate all of the town centre allocations in NLP2 with substantial spare capacity to mitigate any windfall or speculative sites that come forward from the catchment. Now, that 9.69 hectares was absolutely, from the outset of the previous appeal and this appeal, required to be delivered on the site. No question.
Yes, that's not the additional.
Yes, it is additional. No, because there is additional and additional. So look, just start with this.
Yes, but not, sorry, there's two separate
Yeah.
sites here, aren't there, we're talking about?
No.
Two separate SANGs, one's additional land.
No, that's not right. Now, 7.6, just to understand this correctly. So that is we are absolutely required to deliver a SANG of 9.69 hectares under the section 106 from last time and this time, correct?
Yes, right, yeah.
And that SANG would not just mitigate our scheme,
Yes.
it would offer additional capacity to mitigate a further 343 dwellings.
Yes.
Where is that weighted in your benefits?
Well, that's where I refer to that in where I refer to the SANG, give that significant weight.
But you told me yesterday that that wasn't about the strategic offer of the SANG, that it was just about the mitigation. So are we now saying you have included that in your?
Well, there's a further area of SANG that's being proposed through the section 106.
But why then, if you are including, I mean, I don't think that's the same answer I got yesterday, but never mind. Are you going to then up your weight to this from significant to substantial when we move to the bigger SANG in a moment?
Well, I can't do that unless I know that that's
Okay.
going to be delivered,
And then-
which isn't what the 106 is currently saying in its current draft.
Well, look
as I'm informed
Yeah,
by
okay.
the borough
Well,
solicitor.
Look at 7.7 then. The section 106 agreed that the first inquiry covers all matters in relation to the SPA agreed with National England and the Council. This includes an upgrade to the Wealden Heath mitigation strategy package consented with Scotland Park 1 to a full SANG that will provide impact avoidance and mitigation, both phase 1 and the appeal. As outlined, there'll be a surplus capacity to cover residential schemes within a 4-kilometre catchment, that's agreed in section 106. The SANG capacity can be offered at a very competitive rate. So to compare, I'm aware of SANG capacity in nearby Rushmore trading at 6,205 to 14,056 per dwelling, or in Hart, 8,752 to 13,676 per dwelling. The 2,500 per dwelling rate secured in the section 106 is good value. So can I just ask you to note that not only are we providing additional SANG capacity, both on the smaller SANG and the larger SANG, we're offering it at what I could likely call a knockdown rate, aren't we?
Yes, based on this.
Yeah. And the position under the 106 is the SANG would effectively still be on the site, but effectively the parkland area of the appeal scheme would be effectively upgraded to be SANG as well, to meet all of the requirements for SANG. Now, that would require the council to agree to that in due course, because there would need to be some amendments to that area.
Yes.
So that's why the 106 commits us to seek to get the bigger SANG, but can't commit us to deliver it, because the council could turn around and say, I don't want this bigger SANG, and then frustrate the whole scheme if we got planning permission. So we are obliging ourselves to apply for the bigger scheme, the SANG, but it's then up to the council whether they will allow it. And if they don't allow it, we go to the smallest scheme. So, I mean, can we do any more than that? I mean,
Well, how can I, with all due respect, how can I weight it then in that case if there's no no guarantee it's going to be delivered?
well, there's no guarantee, but if this council wants SANG, and let's be honest, they had a call for sites for SANG 15 months ago, so presumably they thought they needed some SANG, then they can approve it. We have to apply for it. The council can approve it. But if they want to be difficult and not approve it, then we fall back to the smaller SANG, which still provides additional capacity.
Yes, but first and foremost, you have to bring the SANG forward in the first place anyway, and that's not guaranteed through the additional SANG, as far as I'm instructed by.
Okay, well, let's talk about this.
That's not in the 106 at the moment, so I can't wait it, I'm afraid. But I have nevertheless, as I keep saying, it's been given significant weight in my proof.
Well, suppose I'm correct that we're obliged to apply for it, and the only reason it wouldn't come forward is if the council turned it down. Surely you can give that weight, because actually there isn't a good reason in the world, is there, why the council would turn it down? Why would you turn down a bigger SANG?
It depends on how it's brought forwards, in what form and what design, whether it's compliant with National England guidance. I don't know. It's supposition. Isn't
Well,
it?
we know it's compliant with National England guidance because they've already told us that it is. That's already in their representation, isn't it?
The
So we know-
additional.
Yes,
No.
the additional. Yes.
I think did National England give the SANG neutral weight? I think.
No, that's
think
going
they-
back to their previous response. We've got
I think
two
they
new
did.
responses that don't say that.
Okay.
Okay.
But I
now-
think the point I'm trying to make is that I've given it significant weight.
All
And
right.
I'm not going to change my opinion on that. I'm afraid.
No, I didn't think you would. Now, I'm not going to talk any further about the scout.
Sorry, before
Yeah.
we leave the SANG, just want to be 100% clear on this. The SANG to which you're giving significant weight is the SANG,
Yes, sir.
not the potential additional SANG.
Yes.
Yes, sir.
And
Yeah.
you haven't factored in, for the reasons you've explained, you haven't factored in the additional area of SANG. Is that correct?
That's correct, sir. Yes.
Okay,
Yeah.
fine. Just want to
Thank
be
you.
No,
clear.
that's helpful. So thank you. Well, I've asked you yesterday about the school, the forest school and the scouts in terms of the weight that should be given to those, which obviously turns on this debate about need. I'm not going to go back. I'm not going to go back over that. I just wanted to ask you a couple of other things about the benefits in your list, and then I think we're done with benefits. You've given, I think it's right to say, we talked about economic yesterday, limited, not going back over that. Energy efficiency, electric charging points. I won't touch on that now. I might come back to it on policy. And providing a minimum of 10% biodiversity net gain, 10% moderate. Why only, we discussed this, I think, but why only moderate for biodiversity net gain? I think you said in your evidence in chief that 10% is a pretty standard requirement these days. But
Yes,
we
that's
agreed,
correct.
isn't it? It's not actually a requirement, is it, for this scheme? Because it was applied for before the Act.
Predates the 12th of February.
Yeah. And there's no requirement in any of the policies for a 10% gain. So therefore, as we've agreed in the statement of common ground, even a 1% gain would meet the policy requirement. So we're well in excess of policy, aren't we?
Yes, it'd be. Yes,
Yeah.
it's a benefit. Yes.
Do you think, yeah, I know it's a benefit, but I mean, given that paragraph 190C directs us to have special regard to the environmental considerations, including biodiversity, and the management plan tells us to look at biodiversity, and we're increasing biodiversity by at least 10 times over the policy requirement, shouldn't that attract rather more than moderate weight?
No, I disagree.
Yeah, okay. And there's also, we're also providing, aren't we, as well as additional SANG that people can buy, there's also provision, isn't there, dealt with in Mr. Collins' proof, about BNG credits that other sites can buy on our site. Have you given that weight?
I've grouped, well, no, I haven't, no.
Okay.
No, I haven't given BNG.
All right. No, not BNG credits, okay.
No.
And then just in terms of other benefits, I mean, you've got a benefit for housing and affordable housing.
Yes.
We talked about self-build and custom build yesterday.
Yes.
Is that just baked into your overall significant benefit for market and affordable housing? You don't weight that separately.
It's a part
Okay.
of that, yeah.
Now, the officer report also recognised that footpath 597 that we're diverting
Yes.
would actually be enhanced because it moves it further from the road and carries out a number of further enhancements. It's, don't have to go to it, but it's CD 4.2, electronic page 47. So the officers thought that there was actually enhancement to that path. You don't give that any weighting, do you, in your assessment?
No.
No, okay. Could we then turn to your 11.4, please, 11.4 of your proof? I just want to run through, I think we've covered all of these points, so we can go through them quite quickly. You set out here a number of material considerations that you consider weigh against the appeal, correct?
Yes.
So I think I just want to tick them off to see that we've discussed them all. We've definitely discussed the previous appeal, so we don't need to go back to that. We've discussed Mead realisations a number of times, and we agreed yesterday, didn't we? There are only 2 paragraphs of the PPG that you are relying on, correct?
We did have that discussion
Yeah,
yesterday.
and we agreed
I
that.
think there may be more than that, but.
Well, okay, what are they then?
I'm
Because
not
I need
going to
to.
argue over it.
Well, no, because sorry, I have to cross-examine you on the evidence that you're relying on. And I put to you yesterday, there were only 2 paragraphs of the PPG that you were relying on and you agreed. If you now say there are more, then tell me what they are. Where do I see them in your proof? What do you say about them?
I haven't counted the number of cross-references, I'm afraid, in my proof.
Okay. If they're not in your proof, can I assume you're not relying on them?
They're not in my proof.
Yeah.
All the points I'm making is I just haven't counted them.
Okay, so they're not in
The
your
number.
proof. If they're not in your proof, you're not relying on them.
No.
Good. The strength and statutory duty, we've talked about that. The update to the PPG, we've talked about that. The statutory duty on the council to jointly maintain and review the National Landscape Management Plan. Well, we've discussed compliance with the management plan.
Yeah.
Increased rate of housing delivery in Waverley. Well, we've discussed the housing delivery test and where the council is on that. And then the scope of meeting the need of development through potential alternative sites as part of the local plan review. Well, again, we very much discussed that in terms of the timetable. So I think we've crossed off all of those points as being discussed. Can I then turn finally to the issue of policy compliance, please? Now, in relation to policy compliance, I want to start with the MPPF. We've discussed at length paragraphs 189 and 90
Yes.
of the MPPF, and I don't go back to those, but could you turn to page 6 of your proof to where you've set out the reasons for refusal?
Yes, thank you.
So the reason for refusal that we are left with, reason for refusal 1, cited paragraphs 176 and 177. So those are now 189 and 190, but also paragraph 180, which is now paragraph 193 of the MPPF, which deals with ecology. And I just wanted to understand, you don't mention paragraph 193, don't think in your proof, don't seem to have placed any reliance on it. Can we cross that one off?
Yes.
Yeah, okay, thank you. Now, other relevant MPPF policies, what we're going to need for this, please, is, I think the best place is the Statement of Common Ground, which is NID 4. If you go to NID 4,
Yes.
and it's 411.
411.
411. So we've agreed, haven't we, a number of, I think it's true to say, we've agreed a number of paragraphs of the MPPF to be relevant. It's on electronic page 9. Yes.
Yes.
Now, as I said, we've discussed the last two, 189 and 90. 193 we've just crossed off. It wasn't on this list anyway, so that fits with you crossing it off, so that's fine. We've also discussed, haven't we, at length, paragraph 11 and footnotes 7, 8 and 9, so we don't need to go back to those.
Yes.
But on the other paragraphs, 2, 8, 9, 10, 11, 12, 39, 51, 61, 21, 131, 135, 182 and 187, those are all agreed to be relevant to this scheme, yes?
Yes.
But all of them, you agree, are complied with, or at the very least not breached by this scheme, correct?
I haven't raised them. I haven't raised a conflict with those in my proof. No.
No, I mean, it follows just as a matter of inference, doesn't it, that if these policies are relevant and you haven't raised them as being breached, then we comply with them, yes?
Yes, I haven't raised any
No.
conflict with those in my proof.
No, okay. So, you know, if you look at some of those, I mean, paragraph 39, I think, is about development being treated in a positive way. Paragraph 51 of the MPPF, not sure why this is in the list, but maybe you can help me on that. Do
I
you know?
don't recall how that was in the.
No, it's prematurity, isn't it, that
It's a
paragraph?
prematurity.
Yeah, okay, so we can probably cross that
matter.
one. Should we cross that one out of the statement of common ground? I'm not sure that's relevant, is
No,
it?
yeah,
No,
I agree with that.
No. Well, I don't know who asked for it to go in, but anyway, doesn't matter. It's out. Paragraph 61. Paragraph 61. That's the one we've talked about a number of times about boosting the supply of housing, isn't it?
Yes,
And paragraph 72, which we've discussed a number of times, that's the one about 5 years supply. Yes, correct.
yes,
And 131, we've also discussed, that's about good design, correct?
yes,
Yeah. Okay. And then paragraph, just wanted to check one with you. Paragraph 187. That's in the list. I think that's the one that was, well, I don't know what. You're not relying on that, are you, as being breached?
Well,
are
this is the
the
dealing
valued
with,
landscapes.
Yeah,
Is it
protecting and enhancing valued
187A?
landscapes, recognising intrinsic character of the beauty. of the
Okay, so it's
countryside.
187As that you're relying on, is that right?
Yes.
Yeah, okay. And then there are other parts, are there, which you would accept of this paragraph that we do comply with? For example, D, providing net gains for biodiversity.
Yes, I'd
Yes.
say B might be one you're in conflict with. A certainly. B, yes, I'd agree with that as well.
Yeah, D we
Intrinsic character and beauty of the countryside.
So D we comply with.
D comply with.
C we well, that's C's not relevant, is it? E, that's not really relevant, I don't think. So it's A. Is it A and B? Is that what you're relying on?
Yes.
Yeah, they're not. That paragraph or its equivalent at the time. Is that cited in the reasons for refusal?
No.
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 All right.
No,
Turn
it's
to the
just helpful context.
All right.
The
Helpful
subject matter.
context.
Yes.
Okay. All right. That's fair. Thank you. Now, development plan policies. Just in terms of general principles, take this quite quickly. I mean, in relation to any particular appeal, policies in a plan can pull in different directions, can't they? So some policies can point in favour of a development and some can point against, correct?
Yes.
And the fact that there's a conflict with one policy or relevant part of one policy doesn't mean there's not compliance with the plan as a whole, does it?
Well, you have to read the plan as a whole, don't you? And you have to apply it as a whole.
No, but what does that mean, Mr. Johnson? Because just listen to the question. The fact there is a conflict with one relevant policy in a plan or part of one relevant policy in a plan.
So a departure from policy.
Yeah, a conflict with one policy in a
Yes.
plan does not mean that a scheme is not in compliance with the development plan as a whole. That's just a trite proposition of planning, isn't it? The fact that you could breach one policy in a plan does not mean you do not comply with the plan as a whole.
How can you comply with the plan as a whole if you're in breach of a policy?
Well, I'm afraid that happens in almost every single case that's ever happened, Mr. Johnson. This is why I wanted to come to this, because I don't think you understand what compliance with the development plan as a whole means.
Because it would be a departure, wouldn't it? If you were
I'm
in
sorry,
breach of a policy, you're a departure from the plan, because the plan has to be read as a whole.
No, fundamentally wrong, Mr. Johnson. And let's explore this a little bit more. I knew there was a problem between us on this. I didn't realise it was quite stark. So let's just go through it. So I can understand your view. You believe if you conflict with one policy in a plan, that automatically means you're in conflict with the development plan as a whole, do you?
Yes.
Okay, right. Well,
there are circumstances where there are material considerations that all goes into the planning balance, but
no. Well,
we're talking about planning policy here and departure from a local plan based on conflict with a policy.
Okay. Well, look, your approach, I don't think you need to take it any further because I can make a submission that that's fundamentally wrong, which it is. But just to understand it, that's how you understand planning works, that if you breach one policy in a plan, that is it. You are not in compliance with the plan as a whole. That's your understanding of how planning works.
Yes, it is. Yes.
All right. Well, I do not need to ask any more questions about that. Thank you very much. And that is just to be clear, that's the approach you've taken in writing this evidence. That's how you've approached this. If there's a breach of a single policy, there is automatically, without more, non-compliance with the plan as a whole. Yes, that's how you.
Plan compliance is part of the case because obviously there's other material considerations, NPPF and so on. Parallel. We don't need to go all over that again.
Not interested in that.
It's
I'm interested.
a very important part of the decision-making process. It's
Yeah.
the development
No,
plan
but
and the policies that are adopted within that.
you,
Now, I take your point. We've just so I can get a bit of context to this. We have got obviously the provisions of para 11, and there's certain policies that will be out of date, and there are certain policies that should be given a lot of weight because where they are compliant with the NPPF.
No, I'm not. I mean, just take an example. It's very simple. Your case and your assessment has been based on the fact that any conflict with any single policy of the development plan means there's not compliance with the development plan as a whole. That's very clearly the approach that you've taken. Yeah.
It is a departure from the plan, and
Right.
then that doesn't mean that you can't take into account other material
Yeah, I know.
PPF. That's
Okay.
fully understood. My
Well,
view is that would be a departure from the plan.
okay, that's all I need. Thank you for that. That's very helpful. Thank you. Now, can I just ask you this? The policies most relevant for determining this application from the development plan are those that are listed in reason for refusal 1, correct?
Yes.
Plus, is it also right, if you look at your proof at 6.4, you look at your proof at 6.4, you, I think, in addition, say that there are other relevant policies that you consider to be important, SP1, ALH1 of the local plan part 1 and H1 of the neighbourhood plan, yes?
Yes.
So can we just agree you would consider those, although they're not, we know, policies that are referred to in the reason for refusal, they are policies that you allege to, not that you allege, policies that you say are most important for determining the scheme?
No, I wouldn't go that. I would say they are helpful context. The most important policies are the ones that are referred to in the reason for
So just the
refusal.
ones in the reason for refusal, okay,
But
that's
there are
fine.
others that are helpful context to the decision maker.
That's fine.
Respect.
And I mean, again, similarly, we'll come to this in a moment, but there's a long list of policies in part 1 and part 2 of the plan, which we've agreed in the statement of common ground are relevant, yes?
Yes, that's right.
And absent the ones that are set out in the reason for refusal, absent those ones that you allege to be breached in your proof, we must agree that those relevant policies are complied with in this scheme.
Accept that, yes.
Yeah, you accept that. Well, I mean, we'll come to the detail if we have to, but okay. Now, do you accept that the policies that are most relevant for determining this application, so those are the ones, in your view, in reason for refusal 1, that they are out of date?
In terms of which policies are in and out of date, you have to go back to para 11, don't you?
Yes, we
The
do.
wording of that.
Yes. So
And just take us back to there. It's a well-trodden path, isn't it?
it is, yeah. So
And it's 11D,
yeah.
I, where it refers to the application policies framework that protect areas. Where is it? The relevant policies it refers to, excuse me. Sorry, it's D, it's 11D, isn't it? Where there are
Yes.
no relevant development policies or the policies which are most relevant for determining the application. So it's the most relevant policies that would be out of date, which are the ones that deal with, in this case, housing numbers.
No. You've agreed already that the policies that are most important for determining this application are all the policies in the reason for refusal 1. Just agreed that, haven't we?
Yes.
Right. So those are the policies most important. All of those policies, SP2, RE1, RE3, DM11, DM15, and H9 of the neighbourhood plan, they are all, aren't they, out of date?
No.
Well, I'm sorry, could we look at the MPPF, please? Again, fundamental, absolutely fundamental. It says the policies which are most important for determining the application. All of the policies and the reason for refusal are policies that are most important for determining the application, correct?
Yes, but I don't, you,
Yes.
it's just down to a bit of, well, yeah, well,
Yes.
I'm not going to give a clear yes or no, because what you're arguing here is that you're trying to run an argument to say that if a policy, for instance, that deals with the national landscape, that is out of date because there's a housing land supply shortfall, you're in direct conflict with the NPPF in terms of footnote 7. So you can't then, it could be, if you carry on your argument, you're referring to policies that deal with flood risk, for instance, potentially highway safety, national landscape here as we have it. These policies are not out of date.
But, sorry, but
As long as they're, as long, you have to give them a lot of, as long as they're consistent with the NPPF.
yeah, you're getting confused now, aren't you? You're getting confused now between two things. There's two things here: whether they're out of date, and then if they are out of date, what weight we give them. They are two separate things, aren't they?
Weighting is a different matter, yes.
Right, okay.
Yeah.
So you're getting confused, and I want to just help you through this confusion because this is obviously a very fundamental part of the NPPF. So let's help you through this. I just need a simple yes or no answer from you because I don't want you going back on this. You agreed with me a moment ago that all of the policies in reason for refusal 1 are policies that are most important for determining this application, correct?
They are the most relevant, yes.
No, I didn't ask you that. I asked you whether all of the policies in reason for refusal 1 constitute the policies which are most important for determining the application, correct?
I'm going to say no, and the reason I feel that is because you're applying a definition of the wording that are most important. The wording are most important
All right.
is clearly here directed at in the NPPF. It's clearly directed at policies that deal with the distribution, the number of houses.
Oh yeah.
This is not.
where
This
does
is
it say
not
that?
what.
Where does it say that? Sorry, can you just point that out to me? Where it says that?
I'm still looking at 11D. Is that
11D.
is that where you are?
11DB. So
B.
where there's reference to policies which are most important for determining the
Yeah.
application are out
Okay.
of date.
Yeah.
And that is a clear reference to policies that deal with the housing strategy, the distribution of housing.
Where does it say
The
that?
NPPF in no way encourages the decision maker to consider policies that deal with really important matters such as landscape, national landscape, to consider that as out of date just because you have a housing land supply shortfall. That's not what the NPPF is
Yeah.
directing the decision maker towards.
Completely wrong. I mean, completely wrong. I mean,
Well, we're
let's
going to have to disagree on that, I'm afraid.
Well, we can disagree on it, but you're disagreeing with the NPPF. So I mean, let's just break it down. I'm not going to spend a lot of time on this because this is really, I mean, this is stuff we should not be in dispute about at all. Really, I don't understand why we are at all. But can I just ask you this, please? I asked you a very straightforward question, which was whether the policies in reason for refusal 1 are the policies most important for determining the application. And you did agree, and now you've backtracked from that agreement. So if they're not all policies that are most important for determining the application, which are the policies that, in your view, that are cited in the reason for refusal, that are most important for determining the application? Let's just go through them. Is SP2 one of those policies?
Yes,
RE1,
yes,
RE3,
yes.
SP1, no, sorry, not SP1, DM15 of Part 2.
Yes.
And DM11 of Part 2.
Yes.
So those are all policies that are most important for determining the application. Yes? I think you just said yes.
But we have to be very, well,
Yeah,
sorry.
we're going down this. It would really help if you said yes or no and then
Sorry,
qualified
sir.
it. You're slightly sliding into giving the explanation without
Sorry,
the
sir.
answer.
I do apologise. I'm going to say no, because I think the reason for the question is that you're trying to associate a definition of policies, of most important policies. You're trying to associate a definition there that there's a reference in the NPPF. That's a very clear reference to policies that deal with housing distribution, housing strategy, housing numbers. And those policies are understandably and quite rightly so out of date where there's a housing land supply shortfall. I support that definition completely. But you cannot apply that same definition to these other policies
Yeah.
referred to in reason for refusal 1.
Where does it say, please, in paragraph 11, that it's only the policies that are concerned with the supply of housing that are deemed to be out of date? Where does it say that in the text or the footnotes? Just to help me out on that.
It doesn't say it in
No,
the text.
okay, good.
No.
Now, I'm going to try this one more time and then I'm just going to move on because it's just, you know, I've tried. There must be, mustn't there, some policies that you consider to be the most important for determining the application. Now, I've tried various ways. I'm just going to open the question up to you. Which policies are most important for determining the application? Give me the list of which policies you accept meet the definition of being the most important for determining the application. I want the list, please.
Well, the policies referred to in reason for refusal 1.
Okay.
So they're the policies that you are in conflict with.
Right. And so those policies are all out of date, aren't they? Because look what it says. The policies which are most important for determining the application are out of date. Footnote 8. This includes for applications involving the provision of housing where you have not got a 5-year land supply. So because you haven't got a 5-year land supply, all of those policies in reason for refusal 1, which are most important for determining the application, are out of date, aren't they? Correct?
No.
Okay.
Fundamentally, no.
Well, fundamentally, that's a deeming provision which deems them to be out of date. So you say that they're not out of date. Okay. Excellent.
Yes, I do. Yes.
Right. All right. Now, LPP1 is more than 5 years old. The council have resolved that the plan needs to be fully reviewed, correct?
Yes.
Right. So it's a plan that's over 5 years old,
Yes.
needs to be reviewed and hasn't been, correct?
There is the review process that's already
Yeah.
started.
When you get to 5 years, you have to decide whether the plan needs to review. This authority's decided this plan does need review,
Yes,
but the
I'm aware
review's
of
not
that.
been completed.
Not completed, no.
Right. But that doesn't, in your view, either in any way render the plan out of date. It's a plan this council thinks has to be reviewed, but they haven't reviewed it yet.
So we've agreed that this plan is out of date.
Well,
We know that.
well, you just told me it wasn't.
Well, sorry. We're talking about housing land supply. and
Sorry,
the application of.
I'm trying to keep up with this, but the one paragraph back on my note, it's an abbreviated note, I know. All out of date, question mark. Answer, not all out of date. So I'm really struggling with this in terms of whether you regard the most important policies are out of date or not. We've got what the reasons for refusal, we've got your answer about reasons for refusal are the most important policies.
Yes.
And I think I've now lost it, and it's probably me as to whether or not those policies are out of date. Are you saying they're not or they are out of date?
I'm saying that the policies referred to in the reason for refusal 1, sir, are not
Not out of
out
date.
of date.
Right.
But what I am accepting, and I think this is my interpretation of the NPPF, is that the most important policies, those dealing with housing, distribution, strategy, they are out of date because of the housing land supply shortfall. So there's a very clear distinction between the policies that are out of date and those that are not out of date. Just because a plan is over 5 years old doesn't render every policy out of date, because some of the policies could be completely consistent with the NPPF.
Okay, I'm with you. Thank you.
But
Sir.
sorry, just one of the policies that's cited in the reason for refusal is policy SP2. Yeah.
Yes.
Is that out of date?
SP2, go to SP2. So if you have that in front of you,
Yeah.
I'm not sure if you need the reference to it or if you have it to hand.
Yeah, it's CD 6.1, I think.
Thank you. Here we are. Yeah, spatial strategy.
Yeah, it's a spatial strategy. I mean, surely given you haven't got a 5-year land supply, you must accept the spatial strategy is out of date. And if that's not out of date, what's out of date in this plan?
Well, the policy, if you just take the first criteria, avoiding major development on land of the highest amenity and landscape values such as A and B and the green belt. Now, you cannot say because you have a housing land supply shortfall that policy is out of date.
So SPT is not out of date. Is this plan out of date? I thought you said a minute ago it was out of date.
It's past the 5-year
Right.
point, so it does need to be reviewed under the
Yeah,
NPPF.
well, no,
Yeah.
no, hang on. Just because it's past a plan can get to 5 years, and then you have to decide whether it needs reviewing. So you could look at it,
Right.
and authorities do, and say, actually, this plan's still fully up to date, don't need to review it further. But this council have said, no, this plan is not fully up to date, it needs to be reviewed. Yeah?
Yes.
Right, so the plan is out of date, because the council say it is. They will need to review it.
You wouldn't render the whole of the plan
No,
out of date.
it wouldn't, but I've tried to establish with you when the individual policies are out of date, and now we're moving to the plan. Okay, can I ask you just this, 2 other things about out of date, and I want to move on because this is not taking us anywhere fast. LPP2 has been said by the council to be a daughter document to LPP1, and that's
Yes.
discussed. There was a legal challenge, wasn't there, to the adoption of LPP2, and the court considered this point about LPP2 being a daughter document.
Yes.
So if LPP1 and its policies, or some of them, are out of date, and I know I don't know what your position is on that, but if the inspector did decide that the policies in LPP1 were out of date, would that not also mean that the daughter document by definition was out of date because it derives from that earlier plan?
No.
No, okay. Again, we disagree. So you think something can be a daughter document, but it's not rendered out of date even if the plan that gives birth to it is out of date. Is that right?
That's not my
Okay.
no.
Now,
That's not my argument.
the neighbourhood plan was adopted some time ago and had a
Yes.
requirement that it needed to be subject to a review within 6 months, and it hasn't been, has it? There's been no progress on a review of the neighbourhood plan.
No.
So is that out of date?
Well, the neighbourhood plan, that's subject to the provisions of the NPPF, isn't it, with the 5-year housing land supply shortfall. So when you have a local plan or the relevant policies, the most important policies become out of date, then by default the neighbourhood plan. And I think there's a slightly different time frame for neighbourhood plans, isn't there, with
Well, the neighbourhood
housing
plan,
land supply? It's
neighbourhood-
3 years rather than 5.
no, because the neighbourhood plan was required to have a review begin within 6 months of it being adopted.
Mhm.
That has not happened, has it?
But this goes back to the same point, doesn't it, about a plan that's past its 5-year point? You don't. Sorry, sir. I'm wandering.
I've actually got a question now.
Sorry.
Yeah, so the question is, this was a plan that was adopted subject to a requirement that it begin to undertake a review of it within 6 months, and that has not happened, has it? There has been no review.
No.
No, okay. Good. Now, if you go back to the statement of common ground, please, CD 4.11.
CD4.
CD 4.11.
Is it CD?
Sorry,
NID.
NID, sorry. NID 4.11. NID 4.11. And if you could go
Yeah.
to page 10,
And
electronic page. Yes, electronic page 10.
yes, thank you.
Now, there follows across the next few pages a list of all the policies in the local plan, part 1, that are relevant to this scheme. Yes, and there
Yes.
are, I think in total, there are 16 policies listed. SP2 is the first one, which is part of the reason for refusal. Yes.
Yes.
There's then ALH1 and AHN1 and AHN3. None of those 3, although they're relevant to this scheme, are alleged to be breached, are they?
No.
So we are in compliance with those policies, correct?
Yes.
Yes. And then I think LRC1, enhancement of existing open space, that's not alleged to be breached, so we comply with that, don't
Yes.
we? There's RE1 and RE3, which are in the reason for refusal, so they're in issue, yes.
Yes.
TD1 is the design policy, that's not alleged to be breached, so we are in compliance with policy TD1 on design, correct?
On design, yes.
Yes. And then you've got policies, if you keep going on, you've got policy HA1 on heritage, you've got NE1, biodiversity, NE2, green infrastructure. You've got GC1 on climate change, or sorry, CC1 on climate change, CC2, sustainable patterns of development to reduce the level of greenhouse gas emissions. CC4 is flood risk, ST1 is sustainable transport, and ICS1 is community infrastructure. None of those are alleged to be breached, but they're relevant, so we comply with those policies, correct?
Yes, correct.
Okay. Now, you accept, I assume, that a number of those policies are in themselves quite important policies. So, for example, AHN1 that we comply with is the policy that requires you to provide at least 30% affordable housing. That's an important policy, yes?
Yes.
We comply with it. In
Yes.
fact, we exceed it, don't we?
Yes.
Yeah. Policy LRC1 that we looked at a moment ago is about the retention and enhancement of open space. That's an important policy.
Yes.
And we do enhance open space. You acknowledge that in your benefits, don't you?
Yes.
And NE1 biodiversity net gain, again, an important policy, but again, you recognise that we comply with that.
Yes.
And then the policies on climate change, like CC1, for example, the officer report sets out in some detail. I'll give the reference, I won't go to it, but it's CD 4.2, electronic pages 50 through to 52, goes through all the ways in which this scheme complies with the climate change requirements of policy. Those are important policies and we comply with them, don't we?
Yes.
Yeah. And the design policies are important and we comply with those, don't we?
On design, yes.
Yeah, on design. Thank you. Good. Now, in terms of the ones that are conflicted with, SP2, I think in your proof, this probably reflects a discussion that we've just had to some degree, but 6.8, I think of your proof under policy SP2. I mean, you seek to give this policy full weight, don't you?
Yes.
Yeah. But this policy, as we looked at it a moment ago, this sets out the, it sets out, doesn't it, the strategy, spatial strategy for the council, yes?
Yes.
Yeah. And this spatial strategy has not delivered at any point, has it, during its life, a 5-year housing land supply in this area, correct?
No, the plan, no, it hasn't. No,
it hasn't.
No, but it does. If you'd like me to expand on that, why I've given full weight to that policy
Well,
is because it refers to very clearly in criteria 1, avoiding major development on land of the highest quality landscape value, such as the OMB, which ties very neatly into 190, doesn't it? Where it
Yeah,
refers to
okay.
Commission being refused.
so that's one. Can I ask you to focus on point 2 of the policy? So this is CD 6.1, electronic page 20, policy SP2.
Yes.
Avoid major development on land of the highest amenity, etc. So I've got your point about that one. Focus development at the 4 main settlements. Now, 2 things. First of all, this confirms, as I debated with you yesterday, that Hazelmere is one of the 4 main settlements in this area, correct?
Yes.
And it doesn't say, does it, focus development in the 4 main settlements. It says focus development at
Yes.
the 4 main settlements. Now, our scheme lies on the boundary of the current settlement boundary. Our scheme is at Hazelmere, isn't it?
Yes, it is at Hazelmere.
It is at,
Yes.
not in Hazelmere, but it's at Hazelmere. Yes.
Yes.
All right, thank you. Now,
Just to
Yeah.
apply a little bit of context to that, sir.
Yeah.
I'm not sure if you have in your electronic version the supporting text to that policy. If you do so, if I can just refer you to paragraph 5.16. In terms of the last paragraph, which begins as a result. So effectively what the spatial strategy is trying to do here is focus development in the most sustainable locations. What it is also doing is seeking to protect the national landscape. In that paragraph, it's referring to the scope for expansion in Godalming and Hazelmere is more limited than in Farnham, Cranley. So yes, it's a very solid principle, focused development in sustainable locations, but there's also a balance here, isn't there? And it's referred to here as obviously there's limited scope in Godalming and Hazelmere. So just a bit of context there.
Okay, so you point to part one of the policy, which is about the protecting the national landscape. I've taken you to part two, which we comply with. Yes.
Yes.
Yes, and we are in a sustainable location in one of the most sustainable settlements.
Yes,
Yes,
we agreed on that. Yes.
yeah, okay, we're agreed on that. Good. And obviously we know, and I think the LPP2 says the same thing, that Hazelmere is possibly one of the most constrained, if not the most constrained of the big towns.
Yes.
Yes. Okay, now, just in addition, if you go, please, through to page 23, or actually page 25 electronically, I think it's yes, 25 electronically, of this plan. There's policy ALH1, amount and location of housing.
Excuse me, I'll have to switch to my electronic version. Right, I have that. Sorry, what was the page number again?
Electronic 25, you got policy
25.
ALH1?
25, thank you.
Yeah, I mean, I suppose just,
Yes, thank you.
yeah, I mean, sorry, just on our way to that, could you just go back to electronic page 23, sorry?
Yes.
Because you were showing me supporting text, but this is supporting text for the policy I'm coming to, which is ALH1, which is the amount and location of housing, yes?
Yes.
Now, this is a policy that we agree is relevant, yes?
Yes.
It's not alleged to be breached, correct?
Correct.
And if you look at the supporting text 6.16, greenfield releases, there's not enough suitable land for housing within existing settlements to meet the need for new homes in Waverley. Therefore, the council strategy for delivery includes making selected releases of greenfield land around settlements. And then 6.17, there are limited opportunities to expand other main settlements of Godalming and Hazelmere through greenfield development on the edges, owing to the constraints of the green belt and the AMB. So again, it shows just how constrained Hazelmere is. But also the council recognise it hasn't got enough land, has it, even to meet the very much lower needs that were in play at this time within the settlements.
No, that's correct. But
Yeah.
what the plan isn't suggesting is that you meet the needs in the national landscape. Yes, you might not be able to meet the needs of Hazelmere.
Well,
it doesn't automatically direct you into the national landscape.
No, of course it doesn't. Of course, it doesn't automatically direct you. But policy RE3, which we'll come to in a second, which encompasses paragraph 190, allows for development in the national landscape if it meets the exceptional circumstances test. Correct?
Yes.
Yeah. Okay. Good. Now, just on policy ALH1, which is on electronic page 20. This policy about the amount and location of housing, ALH1, is itself closely linked to policy SP2 that sets out the strategy, isn't it? They are closely linked policies. The spatial strategy and the amount and location of housing are self-evidently going to be closely linked concepts, aren't they?
They are linked, although they're not specifically. There's no cross-reference to each other. You read both policies side by side, don't you?
Okay. Now, the policy that sets the amount and location of housing, surely we agree that's out of date because that's setting an amount of housing based on a constrained need.
Yes.
Yes, that's out of date. Yeah.
Yes.
Okay.
Yeah.
All right. Thank you. Now, also these plans that we were talking about, LPP1 and in particular LPP2, they have, as we've discussed earlier, allocated sites for development, haven't they, in the national landscape, like the Royal School, Old Grove, National Trust Car Park, correct?
Yes, they have, yes.
Yeah. And there are other neighbourhood plans that we've heard, like Chiddingfold, that also allocates sites to national landscape, correct?
Yes.
All right, thank you. Good. Now, policy RE1, please. You deal with this in your proof at 6.12. This is a sort of general countryside protection policy, isn't it?
We at which policy, excuse me?
RE1.
RE1, yes.
Yeah. Now, in your evidence in chief, I think it must have been a mistake, and you may have meant RE3, but you said in your evidence in chief that RE1 fits within footnote 7 of the NPPF. Now, that's not correct, is it? Protection of the countryside, ordinary countryside, is not a footnote 7 policy, is it?
No.
No. Okay. Now, just on this, I mean, this is a countryside policy, as we know, generic countryside policy. In an area where you haven't got a 5-year land supply or anything like it, are you still suggesting that a policy like RE1 carries full weight, notwithstanding the absence of any 5-year supply?
I think we have to be a little bit, well, you're asking for a yes or a no.
I am, to start with. You can qualify it, but
Yes.
is it still fully up to date, even though it constrains housing because it's a countryside policy and you haven't got anything like a 5-year land supply?
I don't know. I don't think we agree on this because what the policy is referring to, yes, it's dealing with countryside. And yes, you could argue that if there's a policy of constraint on development in the countryside, that is out of date. But this policy is referring to the intrinsic character and beauty of the countryside, recognised and safeguarded in accordance with the NPPF. So it's specifically referring to in accordance with the NPPF.
Okay, well, I mean, we disagree very much on that.
It's dealing with character and beauty. But
RE3, I mean, can we deal with
Just before we move on,
Yeah.
Mr. Parucci, how are we doing? And
I reckon I've only got about 20 to 30 minutes left maximum.
are you okay with that?
that's fine, sir. Yes.
Run that through, run that through to the lunch break, and there'll probably be some re-examination, which we could do after lunch. But yeah, let's keep going then.
Yeah. RE3, I hope we can kind of short circuit, because if you look at the policy, so if we go to CD 6.1, page 64, electronic page 64, policy RE3, this policy at part 1 specifically cross-refers you, doesn't it, to the national planning policies in the NPPF, yes?
Yes.
Yes. So just to be clear, if we get to a position where the inspector decides that there are exceptional circumstances for the grant of planning permission under paragraph 190 of the NPPF, then we would also be compliant, wouldn't we, with policy RE31?
Yes.
Yes. Good. Okay, thank you. And then on local plan part 2, so we need to move to CD 6.2. There are 2 policies alleged to be breached in the reason for refusal, DM11 and DM15.
Yes.
Now on DM11, I mean, well, before we get to those, again, there are, I think, in the Statement of Common Ground, 12 policies listed in the Local Plan Part 2 that are relevant to this scheme, 10 of which you don't allege to be breached, 2 you do. So again, we can take it in the same way, can't we, that the council's position on those 10 other policies is that we are compliant.
Yes.
Yes. Now, DM11, please, could we go to that? I think it's electronic page 40. This is the tree policy. Now, there is obviously some tree removal as part of the appeal scheme principally at the access, although there are a few other places elsewhere on the site. But there is also, isn't there, as I discussed with Mr. Petro, extensive new tree planting across the site, yes?
Yes.
So many more trees will be planted than lost, correct, overall? We agreed that with Mr. Petro, didn't we?
Yes. Yes.
Now, in DM11, electronic page 40, you'll see it says development should retain woodland, important trees, etc. And then under those list of A, B, C, D, E, it says where significant harm to existing woodland and important trees and hedgerows cannot be avoided, it should be adequately mitigated for, or as a last resort, compensated for. Yes?
Yes.
And then if you look at the very last paragraph of that policy text, before you get to the explanatory notes at the bottom of the page, the council may attach planning conditions and seek planning obligations or make tree preservation orders to ensure future protection and in management of important trees, including new planting where appropriate. So, first of all, this policy explicitly contemplates the possibility of trees being removed by development, doesn't it?
Yes, it does, but it also there's also wording in there as well. The paragraph you've missed, you've leapfrogged the paragraph, haven't you? Where it's referring to
Which one have I skipped?
proposals which would result.
Yeah, but that's about replacement of irreplaceable habitats. That's ancient woodland. Or detrimental.
Impact on the landscape character of the area will not be permitted.
Right, I was going to come to that one, unless there are wholly exceptional reasons and a suitable compensation strategy. So that policy, that part of the policy also recognises the possibility, doesn't it, of there being tree removal, so long as you provide compensation and so long as there are exceptional reasons, yes?
If you are able to compensate, yes,
Yeah.
the detrimental impact on the landscape
Yeah.
character.
So just two things. This policy overall recognises that trees may be removed by development, but requires that you mitigate and compensate by planting new trees, correct?
Well, it refers to a suitable compensation strategy.
Yes, it does. And so the policy expressly contemplates removal of trees, compensation, replacement, new planting. It specifically refers to new planting, doesn't it?
Yes.
Yeah. Now, if the inspector were to decide that there were exceptional circumstances under paragraph 190 for this development and under RE3, we would also, surely, would we not meet the exceptional reasons test in this policy?
Yes.
Yes. And insofar as there's a requirement to ensure through conditions on 106 that there is new planting, there is management of the new planting and indeed the existing planting, all of that is to be secured, isn't it, through conditions on the 106?
Yes.
Yeah, okay. So then that leaves DM15 in terms of this plan. So could we get an electronic page 73? Now this is a policy that if you go to actually back to page 72, do you see there's a heading development in rural areas? That's the subheading. Do you see that on page 72?
Yes, I do. Thank you. Yeah.
And then at 3.31, it refers to policy RE1, and then so does 3.32. And then you come into, on the next page, DM15. So this policy, DM15, is a policy that's closely related, isn't it, to RE1?
Yes.
Yes. Now, it says rural area, and I think the policy means it applies to all land outside settlement boundaries. Is that correct?
Yes.
Yeah, okay. Now, just looking at the policy itself, 3 parts, A, B, C. In rural areas, development should, A, not be isolated from everyday services and facilities while maximising opportunities for walking and cycling and seeking to avoid dependency on private vehicles, taking account of the nature and functional needs of development which are acceptable in rural areas. We're agreed that in transport sustainability terms, the site is sustainable and accessible to facilities. So there's no breach of Part A of that policy, is there?
No, it's a fairly standard requirement, isn't it?
Okay. B, recognise the natural beauty and undeveloped character which is intrinsic to the open countryside, together with the distinctive character and pattern of development in areas of urban-rural transition and rural settlements, while making efficient use of land. So this is the bit, I think, I hope you'll agree with me, that's most closely related to what policy RE1 provides, isn't it?
Yes.
Yes. And it refers to the distinctive character and pattern of development in areas of urban-rural transition, yes?
Yes.
So this site is currently on the edge of Hazelmere, and Hazelmere is immediately north of the site, as we know, yes?
Yes.
Now, I don't want to go back over this evidence, but one of the things the inspector will have to consider, and I touched on with Mr. Petro, is how attractive is the current edge of Hazelmere at present, and how attractive would the edge of Hazelmere be if we were permitted development? Those are relevant considerations, aren't they? They are, yes, thank you. And then in terms of making efficient use of land, I mean, if you're going to develop this site in the national landscape, we are developing, I think, is it 22% of the site, and enhancing in landscape terms the rest of it. You don't suggest, do you, it's not part of the council's case to say that we're not making efficient use of land through this proposal?
No, I'm not suggesting that, because the parameter plans establish the net developable area, don't they? The
Yeah.
outline part at least.
They do. Okay, good. Now, could we then just look at C, recognise the benefits of areas of best and most versatile agricultural land? That's not a policy that the council have ever raised as being an issue, correct?
No.
Okay. So if we're in breach of this policy, it's really, in your view, about the first part of B, yes?
It is B,
Yeah.
criteria B, yes.
Yeah. Not the efficient use of land bit, but the rest of it.
Yes.
Yeah. And that's the bit we've said is linked to RE1. Now, on that, I mean, presumably, you would accept that, I mean, ultimately, if the inspector accepts that there are exceptional circumstances that overcome the paragraph 190 in the RE3 test, you're not suggesting, are you, that these policies would justify refusal in themselves, having reached the conclusion that there are exceptional circumstances to justify the development?
No, I don't.
No.
No. Suggesting that.
No. On the neighbourhood plan then, please, which is the last of the policies, I think, that's CD 6.3. Now, the first thing is the only policy from the neighbourhood plan cited in the reason for refusal is H9 on trees, correct?
Yes, correct.
But I think you do also refer to H1 in your evidence.
Yes.
Well, can I deal with H9 first, please? So I think H9.2. So if you go to page 36 of this document.
Yes.
H9 starts at the bottom of page 36. It runs through, it's quite a number of subparas, H9.1 to H9.7. Which is the bit that you allege that's breached? Is it H9.2?
Point 2, yes.
Yeah, so point 2. None of the others, is that correct?
Correct.
Yeah, okay. And then could we just look at H9.4? And you'll see it begins, development proposals that affect trees, hedgerows, woodland should demonstrate, etc. And then if you go down to the next paragraph, after the long paragraph, it says trees proposed for removal should be specified in a tree removal plan. Replacement planting should be specified in a tree planting landscape plan. All landscape and replacement planting specified within the application as permitted should be completed before the dwellings are occupied. Now, two things. I mean, one is, again, this policy is explicitly contemplating, isn't it, the possibility of trees being removed as a result of development, correct?
Yes, correct.
And secondly, insofar as it's laying down requirements about replacement planting and what must be dealt with in the section 106, we are offering a 106 and conditions that will ensure compliance with those parts of the policy, yes?
If I may just to clarify your question,
Yeah.
compliance with which parts of the policy?
H 9.4, the
Point
two
four.
paragraphs that we've just referred to.
Yes, sorry,
Yeah,
just wanted
yeah,
to clarify, we're
yeah,
not talking
yeah,
about
yeah,
9.2 or the policy as a whole.
Good. Okay, thank you. Now, the other policy that you mentioned is H1, isn't it?
Yes.
And in relation to that, is it right that it's H1.3, I believe, that you mention in your proof, paragraph 6.17 of your proof, is that right?
Yes, that's my focus, yeah.
And is that the only part of H1 that you allege to be breached?
Yes.
Okay. And could we just look at that then, please? H1.3. So this is electronic page 18. H1.3. So the heading is designation and purpose of the settlement boundaries. H1.3. Development outside the settlement boundaries will be strictly controlled. Development process in such locations will only be supported which otherwise conform with national and local planning policies. So again, I mean, this is similar, isn't it, to what we've looked at elsewhere in the plan about constraining development to settlement boundaries, and the whole discussion we've already had about whether that's out of date, 5-year land supply, the same would apply to this, yes?
Yes, yes, I believe that policy is hooking into paragraph 190 of the MP of the framework.
Well, is it? Because this is not a policy that's confined or about in any way national landscape, is it? This is a policy that's simply about settlement boundaries. I don't know.
It's not, well, no, it's not just about settlement boundaries. It's referring to accepting that, you know, if you do go outside the settlement boundary, there just needs to be strict controls. And then it's obviously in reference to the national planning policies, it hooks into 190, doesn't it? So,
well, I'm sorry, I don't see where it does. This is a settlement boundary policy. It's got nothing to do with national landscape. It applies generally.
It's just, sorry, I disagree.
Okay.
It refers to strict controls, and I think strict controls are very relevant to the discussion we're having.
Well, no, because
today.
your plan applies strict controls to any development in the countryside. See RE1. Isn't this just a version of RE1? Development in the countryside outside settlement boundaries. It's nothing more than RE1 in another form, is it?
It's very well. It's very consistent with RE1, yes, as it should be as neighbourhood plan policy.
All right. Now, on that, it says you'll only allow proposals to happen if it would otherwise conform with national and local planning policies. I mean, if the inspector concludes we meet paragraph 190 and RE3 of the local plan, exceptional circumstances, then we'd comply with this policy too, wouldn't we?
Yes.
And then it's also, I think, correct, isn't it, that in relation to the neighbourhood plan, there were some words added, weren't there, by the examiner in relation to those words: development proposals in such locations will only be supported which otherwise conform with national and local plan policies. Those words were added, weren't they? And Mr. Collins deals with this in his proof, by the examiner in order to ensure that they didn't too strictly control development within settlement boundaries. Is that correct? Yes. Thank you very much. Those are all my questions. Thank you, sir.
Thanks very much for that, Mr. Marici. I'm assuming that there is some re-examination.
Yes, I expect about half an hour.
Yeah, let's take a break. I'm sure the witness needs a break. I certainly do.
Yeah.
I tried to cover my computer crashing with paper face. I think the Del Harris best one.
Oh dear.
And so what's the plan if are we taking an hour for lunch? And are we going to start evidence in chief, I guess is the question.
Evidence in chief is a couple of hours, isn't
yes.
it?
We're not going to finish it.
We're not going to finish it. I'm concerned about next week, but that said, I don't want to get the evidence halfway through today,
No.
which is the best we would do.
No.
So where are we now? 20 past. Yeah, we may as well break till 15:15, please.
Yes.
Uh,
Well, so I think,
good.
I think in any event, we are probably inevitably going to go into Thursday, even if we sat longer today, because we've got a couple of hours in chief. I think Mr. Cosgrave has said, was it 4 to 5 hours, you said, probably?
It entirely depends
Something
how
like that.
compliant Mr. Collins is. but
Okay,
yes,
10 hours.
four,
10 hours.
Oh, I see.
And
He's like
and then
you. He's like you,
and then
Richard.
Mr. Brown has
Yeah.
got half an hour, I
Yeah.
think we said, something
Yeah.
like that. So I mean, I think inevitably it's not inevitable, but we probably will go into Thursday, but probably only the morning, I would think.
Yeah.
And then I think there's a question about what we do about the site visit, whether you
Yeah,
want.
site visitors then, I mean, we can deal with this, but the site visit, I think, is then going to give me a problem. Because actually on site, to walk around it, hour and a half, maybe, that sort of thing. I'll probably do a lot of standing and looking, but call it an hour and a half around. And then on my own, I've got a good few hours worth of surrounds of the site and various other locations that have been mentioned. We could have a problem on Thursday, or I could have a problem on Thursday, but let's leave that. We'll break now till 2:15, and then the only business apart from picking up on housekeeping will be re-examination. I don't really want to start on evidence in chief at this point, whatever the implications for next week may be. So we'll adjourn now till 2:15 and come back for re-examination. Oh.